Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello. Hello, my friends, and happy Memorial Day for all of those of you who have a holiday today. Welcome. So many of you have been in withdrawal from 5 days without trial. It feels like a long time, doesn't it? Because we've been living this for over a year together. Over a year. Many of us have been here for a year and a half together covering this Karen Reed case, and now the inexplicably intertwined case of Aidan Kearney, aka Turtleboy. And if you haven't been following the Aidan Kearney case, the link to the playlist for all of the coverage that we've done on this case is linked in the show notes below this video, so you can catch up. Can you believe this motion to dismiss the indictments has been pending since February? I don't know why that feels so long ago, but it was filed in February. And very quietly, a week ago, this decision was filed that Judge Doolin wrote. And has anyone covered it? This is a Paris Ray and the Crush hat. Isn't this awesome? They had their album release party last night, and it was so fun. And if you follow me on Instagram, I will be posting video later. It was amazing. It was really, really, really great. Somebody said here that she watched yesterday's show 5 times. What? Ashley, you watched yesterday's show 5 times? So you're the one. You're all the views on that show. Thank you. Thank you, Ashley, very much. My laugh is contagious. Yeah, Bev had to get her award, Sydney. You know, she had to get her award, and so there was no trial on Thursday, and they could have called Judson Welcher, but, you know, they're going to save him for tomorrow, and we're here for it. I put up the show already for tomorrow. 3 months to issue a decision that long isn't a long time at all. No, I don't think it's a long time at all. I'm just saying it feels to me like February was a year ago. That is what I'm saying. I'm not saying that it takes a long time. Listen, we've seen Judge Kearney take 6 months for a decision, but I feel like February was so long ago that it's my own personal internal clock, which has been drifting greatly. My clock is drifting. Is your clock drifting? Which clock is correct? I don't know. The monatomic clock, the atomic clock, the iPhone clock, the internal Lexus clock. I have no idea. I have no idea which clock is correct. And I don't think anybody really knows which clock is correct because time drifts. Time drifts. Personally, I think that since 2020, I think whatever age you were turning in 2020, you should get to be able to turn again this year, because I feel like we all lost, I don't know, at least 3 years of our life, 3 good years too. We lost 3 good years, in my opinion. And yeah, the microwave clock, I think, is the one that's correct. You know, the one that reads 2:27. Well done. Clerk of the Year 2027 coming in hot. Coming in hot. Happy Memorial Day. And I'll just give thanks and praise for each and every brave soldier men and women that gave their lives in honor of this country, which is supposed to be the greatest country in the world with the greatest systems in the world and the greatest rights, the most rights out of any country in the world, and where the Constitution is supposed to give certain rights to each and every American. And yet here we are back in the state of Massachusetts, where the Constitution goes to die. Apparently, it's where it was born. I think it was the birthplace. Was it the birthplace? I don't know. It's where the Pilgrims came, anyway. And it's apparently where the Constitution goes to die. So, yes, Judge Kearney was awarded. She was awarded Person of the Year at the Norfolk County Bar Association dinner, which was held last Wednesday night. And look at this. Marianne's in Italy right now. And all her favorite cupcakes are here. Oh, speaking of cupcakes, check this out. I don't know if I can pull this picture up. Bob and Allie from Defense Diaries sent me, maybe I can just show it to you on my phone, sent me cupcakes for my 100,000 subscriber, like as a congratulations gift. You got to see this. Hang on. They're amazing. Can I, wait, let me take myself off the screen here. Can you see these cupcakes? They're like Grateful Dead cupcakes. I don't know if you can even see it. Can you see it? They're like dancing bears and Grateful Dead, like steal your face type stuff. And they're awesome. I think I can get the picture up on the screen if you can't see them. But thank you to Bob and Allie of Defense Diaries. That was the sweetest gift. And they're really delicious. I've had too many of them and they are too delicious. So we have to have some sort of a celebration for the 100,000 subscriber mark. There just really hasn't been time because here we are in the upside down, inside out matrix that is Norfolk County, Massachusetts, and we're going back there tomorrow. And it's pretty crazy. How can we get to this? Hang on a second. So how are you? How's everybody? All right, here we go. Here's the cupcakes and a better view of the cupcakes. Thank you to Bob and Allie, because that was super nice. Look at those cupcakes. Are they amazing or what? And they're so delicious. They're some are chocolate, some are vanilla. And how cool is that? And the design on top is edible, so even better. I mean, awesome. All right, so here we go. Let us take a look at this this decision and order on the motion to dismiss that came out a week ago on May 19th. And has anybody covered it? Do you know if anybody's covered it? It's going to be hard for me to watch the chat while I am reading to you because this will be an ASMR stream. I will be reading to you. It's 37 pages long. Judge Doolin. Declaration of Independence was signed in Boston, see, and that is where it's going to die, Michael Tibbetts. Thank you. I don't think I paid so much attention in history class. So I rely on you. We're a very collaborative chat. We're a collaborative chat. Collaborative, we're collaborative, we're all of it. All of it. Turtleboy talked about it. Oh, he didn't read it though, did he? Okay. So we're going to read it. We're going to read it in full detail, in all its glory. And we're going to talk about it. And we're going to see what's going to be coming up next in that case. Let me just take a look here because I think there is a trial date. So no spoilers if you have read it, but we will get to all the nitty gritty. And we did do a reading of the motion to dismiss. And then we also we covered the hearing on the motion to dismiss, and all of that's in the playlist if you happened to have missed it. So let's take a read through, shall we? Try and save your questions if you don't mind for later, because again, I have to make this so large that I have to so I can read it to you. Okay. The Commonwealth versus Aidan Timothy Kearney, the memorandum of decision and order on defendant's motion to dismiss, filed by Judge Doolin. I don't know that we like Judge Doolin so much. Do we like Judge Doolin? Was Judge Doolin cool? Or we liked Sisitsky, right? And we also liked the Stanley Tucci judge who presided over the Turk trial, Mark Halal. We like him. There are some very good judges in Norfolk County who have been very fair And it just goes to show, had Karen Reed's trial been assigned to a different judge, how much different everything would be. The trial, the pre-trial, all of it. Here we are. Halal. Yes, it was halal. He's the Stanley Tucci one. Doolin's okay. Well, Aunt Bibi, you might not say so after this decision, but we're here for it. I haven't read the whole thing in its entirety, like I usually do. I skip to the end to see what the final decision is. But here we go. Memorandum of decision and order on defendant's motion to dismiss. A Norfolk County grand jury indicted the defendant, Aidan Timothy Kearney, with 8 counts of witness intimidation in violation of General Law 268-13B. Footnote 1 says that those indictments are numbered 1 through 8. 5 counts of unlawful picketing to influence a witness in violation of General Law 268-13A. Footnote 2 says that those are indictments 9 through 13. And 3 counts of conspiracy to intimidate a witness in violation of General Law Section 274-7. Footnote 3 says that those are indictments numbered 14, 15, and 16. Kearney moves to dismiss all counts. The court conducted a non-evidentiary hearing on the motion on March 6th of 2025. After careful consideration, the court concludes that the First Amendment does not insulate Kearney from the indictments. However, because the evidence presented to the grand jury was insufficient as to some of the indictments, Kearney's motion to dismiss is granted in part and denied in part. So you're going to have to wait until the end to find out which ones. Background. Footnote 4. The court reserves some facts for the discussion section. The case against Kearney was brought before a grand jury over the course of 7 dates between November 28th, 2023 and February 22nd of 2024. I'm going to break for a second to just remind you that Aidan Kearney did not start covering the Karen Reed case or writing about it until April of 2023. So within 7 months, they had convened a grand jury to try and shut him up, in my opinion. Footnote 5 says the case was presented to the grand jury on the following dates: November 28th, 2023, December 5th, 2023, December 14th, 2023, December 19th, 2023, December 20th, 2023, February 1 of 2024, and February 22nd of 2024. As pertaining to the above referenced charges, the evidence included testimony from Detective Lieutenant Brian Tully, Trooper Michael Proctor, Elizabeth Proctor, Jennifer McCabe, Matthew McCabe, Christopher Albert, Colin Albert, Brian Albert, Juliana Nagel, Sergeant Yuri Buchanan, and Lieutenant John Fanning. The evidence also included numerous video exhibits. Well, doesn't Tully have his hands in everything involving not only Karen Reed's case, but also Aidan Kearney's case? A. Defendant's interest in the Reed case. Kearney is an internet reporter, local blogger, and activist who operates several websites and social media accounts under the name Turtleboy. Kearney's followers are referred to as Turtle Riders. The indictments at issue arise out of Kearney's coverage of Commonwealth v. Reed, Massachusetts Superior Court, a case currently pending in Norfolk Superior Court. Reed is charged with second-degree murder, manslaughter while operating under the influence, and leaving the scene of the motor vehicle accident after personal injury that resulted in death. The Commonwealth's theory of the case is that Reed, while under the influence of alcohol, backed her vehicle into her then-boyfriend, John O'Keefe, after dropping him off outside the residence of Brian Albert. Reed's defense theory is that Reed was framed and that O'Keefe entered the residence where he was fatally beaten in the basement and possibly attacked by a German Shepherd before O'Keefe was placed outside on the front lawn. In or around April of 2023, Kearney became heavily involved with reporting on the Reed case. Since then, Kearney theorized that Reed is being framed for O'Keefe's murder and that people in the residence that evening, as well as the investigating officers, either killed O'Keefe or were complicit in the cover-up of the crime. B. Wait, where's that footnote? Oh, B. Defendant organizes a rolling road rally, footnote number 5, I think, or 6, which I can't read, that number's too small. The 5 indictments under General Law Section 268, Section 13A are related to the rolling road rally. Did any of you participate in that rolling rally? Just curious. Let me know if you did. Because Kearney was the only one charged. I think how many people were in that rolling rally? Well, maybe they'll tell us. I think it was around 100. Kearney organized and broadcasted a rolling road rally, the rally, to lead his followers to the homes of various witnesses and the lead investigator in the Reed case. At around noon on July 22nd of 2023, Kearney and his followers met in a supermarket parking lot in Norwood, Massachusetts. Kearney recorded the rally as he and his followers drove from one witness's residence to the next, accusing the various witnesses of being involved in the murder of O'Keefe. Oh, you were at the rally? A couple of people were there. DMB 22, Liz ERK was there. Kearney and his followers stopped outside of Brian Albert's residence in Norwood, Massachusetts. Brian is a retired police officer and a witness in the Reed case. While at Brian Albert's residence, Kearney used a bullhorn to call Brian Albert a murderer. Footnote number 7. Kearney's followers were also yelling, calling Brian Albert a murderer. Grand jury transcript, December 19th, 2023, page 10. At some point, Kearney or his followers noticed Brian Albert had a camera outside his home and began to tell Brian that he better tell the truth and that he's a liar. Grand jury transcript, December 19th, 2023, page 10. Brian Albert testified that on that date, he believed Kearney and his followers were attempting to intimidate him and his family. Grand jury transcript, December 19th, 2023, page 10. Another stop at the rally was the home of Trooper Michael Proctor, who was a Massachusetts state trooper assigned to the homicide unit of the Norfolk County District Attorney's Office. Trooper Proctor was the lead investigator in the Reed case. Oh, well, that's interesting because Judge Doolin is also calling Michael Proctor the lead investigator in the Reed case. That raised judicata now? Anyone? Bueller? There it is right there. Trooper Proctor was the lead investigator in the Reed case, according to Judge Doolin, who's also sitting in Norfolk Superior. Trooper Proctor testified that because he knew about the event in advance, he got his family out of the house that day so that they were not home when Kearney and his followers showed up. Grand jury transcript, December 14th, 2023, page 41. Although Trooper Proctor was not home during the rally, he watched as dozens of people and vehicles showed up at his home on a security camera. Trooper Proctor testified that one of Kearney's followers parked on his front lawn and another spat at his house while driving by. Grand jury transcript, December 14th, 2023, page 41. Watching the dozens of people in front of his house, realizing they know where he lives with his family, gave him genuine concerns about his family's safety, in quotes. Grand jury transcript, December 14th, 2023, page 41. The rally also stopped at Jennifer McCabe and Matt McCabe's residence in Canton, where they live with their 4 children. Jennifer and Matt McCabe are witnesses in the Reed case. Jennifer and Matt testified that Kearney and approximately 50 to 75 of his followers showed up at their residence while they were home with their 2 oldest daughters, footnote 8. The McCabes were aware that the rally was going to occur, so they sent their 2 youngest daughters to another location. Well, if they knew, why didn't they, I don't know, go out to eat or something? I don't know. If you knew it was coming, I mean, okay, well, I guess we'll get to that. That was the grand jury transcript of December 5th, 2023, page 28. Kearney stood outside of the McCabe residence with a bullhorn and repeatedly yelled that Jennifer and Matt are cop killers. The grand jury watched a video Kearney recorded of himself as he yelled that that Jennifer and Matt are, quote, going to try to live like nothing's happened, but we're not going to let them do that. because you don't get to kill police officers and fathers and get away with it. You certainly don't get to frame innocent people who did nothing wrong to you and send them to jail for the rest of their life. End quote. Grand jury exhibit Rolling Rally McCabe residence. Jennifer testified that she believes Kearney is trying to get her to not testify. That is contained within the grand jury transcript of December 5th, 2023, pages 30 to 32. The final stop of the rally was Juliana Nagel's residence. Juliana is a witness in the Reed case. Juliana testified that on the day of the rally, Kearney and approximately 25 to 30 people stood outside her home. Okay, so it went from 50 to 75 people at the McCabe's to 25 to 30 outside of Juliana Nagel's. Did people like drop out of the rally in between the two stops? Was somebody wrong about the... Scott, you're on it. Scott, how about the Knicks winning last night? Was that crazy? That was so crazy. What a great game. I'm not even into basketball. I have questions. Okay. Kearney, well, wait. 25 to 30 people stood outside her home. Kearney videotaped himself as he used his bullhorn to accuse Nagel of being part of the cover-up conspiracy. While using his bullhorn, Kearney tells Juliana that nothing is stopping her from telling the truth, from saving herself, and that she knows what happened that night. Grand jury exhibit Rolling Rally Nagel video. At the time of the rally, Juliana was home with her mother and friend. She testified that having that many people outside of her home was scary and that she felt intimidated, a little scared, and uncomfortable. Grand jury transcript, December 19th, 2023, page 16. Juliana believes that Kearney is trying to get Juliana to change her testimony. Grand jury transcript, December 19th, 2023, page 17. Can you guys tell me when it was that Aidan Kearney was arrested and sent to jail? Was that December of 2024? Before? I guess it was. It was something, wasn't it? Something like, was it December of 2024 or December of 2023? End of 2023. Okay, so they're saying that this grand jury went on after that into February. Okay, maybe there's other charges that he went to jail for 60 days, right? Christmas 2023, right? So I thought this grand jury concluded. Did they convene another one in February? Okay, because I'm confused. Maybe the conspiracy, in 2024? Right, because I remember it was Christmas, right? And the thing that happened with Lindsay was like right before Christmas. It was like Christmas Eve or something. Okay. Cool. So he was arrested and he was in jail while they were convening another grand jury, because in the beginning of this decision, it says that there was also dates in February 2024. Okay. We'll figure it out as we go through it. Yeah, I know. And I've been through this case 100 times, so I'm just wanted to refresh my own recollection. Okay. Other conduct. Footnote 9, which says the 8 indictments under General Law 268, Section 13B are related to Kearney's voicemails, telephone calls, blogs, video blogs, other protests, and unexpectedly showing up to witnesses' homes, businesses, meetings, and sporting events. In addition to the rally, Kearney has contacted the various witnesses and their family members, shared the witnesses or their family members' personal information online, and has posted videos and blogs of accusing the various witnesses of their alleged involvement in the murder of O'Keefe. As pertaining to Chris Albert, Julie Albert, and their son Colin Albert, Detective Lieutenant Tully introduced the following video exhibits that were filmed and broadcasted by Kearney. So they're using all of his own videos against him. It's just like another form of self-snitching, I suppose, but they're going to use it against him. Footnote number 10. As for Chris's involvement with the Reed case, Chris was part of the group that was with John O'Keefe and Reed at 2 bars in Canton The night leading up to O'Keefe's death. Well, that's not really true. He was not at CF McCarthy's. He was at the waterfall, so he was at one bar, but we can't expect everyone to have the details right. Chris, however, left the group before they went to Brian Albert's home. Well, not according to Chris Albert's original statement, which said that he followed back to 34 Fairview. If you know, you know. And then after that, he ran for and won a seat on the Canton Town Select Board, as it says here. Chris is a member of the Canton Select Board and owns D&E Pizza in Canton. He is also the father of Colin Albert, who is another witness in the Reed case and is Brian Albert's brother. In various YouTube broadcasts, Kearney called Chris's cell phone, Colin's cell phone, and Julie's cell phone. Grand jury transcript, December 14th, 2023, page 4. And here are the videos that were introduced by Tully at the grand jury. Episode 590, Call to Julie Albert. Episode 598, Life as Normal is Over. Episode 598, Time to Hit the Gas. I don't know, that could be a typo. I don't think he has 2 episodes, 598, but I don't know. Episode 618, No Right to Live Peacefully. Impromptu Live, 8/7/23, Albert Should Be Afraid. Footnote 11, which says, in this video, Kearney states, dude, these guys are not the Sopranos. They sell crappy pizza in Canton and run the Little League. That's it. That's their power. They're nothing. Like, these guys are like, we're freaking hardos. Okay, cool. Yeah, I've never heard you before this. Never heard of you before this. But okay, I guess we're all supposed to fear the pizza boy. Chicken Parm Charlie. We're supposed to fear that guy. Give me a break. I don't know what all these people are afraid of. I mean, just for the people living in Canton, like, you're living in this Canton bubble. No one outside of Canton is afraid of any of these people. I'm certainly not afraid of Brian Albert or Colin Albert or any of these punks. They're afraid of me. They should be. I would be if I were them. Next video was called Kearney Outside D&E Pizza, Kearney Outside D&E 2, Kearney Outside D&E 3, and Kearney Outside D&E 4. Grand jury transcript, December 14th of 2023. I just want to point out here that no matter how much you hate Aidan Kearney or like Aidan Kearney, the question here is about the First Amendment. Is this protected speech under the First Amendment? And is the Massachusetts witness intimidation statute unconstitutional on its face, which is something that Tim Bradel and Mark Betterow have been arguing on his behalf. They've also been arguing that it's selectively prosecuted or persecuted, and the only people being prosecuted with the witness intimidation statute are the people who think that John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. The argument, one of the arguments in the original motion to dismiss was that all of the things that Aidan Kearney said are protected speech because in order to violate the First Amendment, they have to be fighting words or true threats. In these videos, Kearney advises Chris and his family to stop going out in public and shares that he knows Chris's whereabouts. Grand jury transcript, December 14th, 2023, page 5. Grand jury exhibit, episode 598, Life as Normal is Over. Specifically, Kearney states, I confronted this guy a couple of weeks ago. Footnote 12 says Kearney is referring to Chris Albert. This guy has his head on the swivel. Everywhere now, he's turned around like, where are they? Got bad news for you, Chris. I got really bad news for you. They're literally everywhere. You can't, like, you guys should just stop going out in public. Like, that would be my recommendation, and it's only going to get worse from here. It's only going to, I did not direct this person to do this. I can't stop them. They're everywhere. They don't like you. Nobody likes you. You guys killed someone. Like, you literally killed someone. Not you. You didn't do it. Yeah, you raised someone who did it. And, you know, your big bro did it. But, like, and you obviously know this and you're helping to cover it up. But I guess you didn't kill anyone. So you've got that going for you. So good job, Chris. You just raised a killer. Chris, I know where you guys were today. You were all in Agawam. Am I pronouncing that right? You're on Agawam, weren't you? I got pictures of you in my cell phone. I got people sending me pictures. You guys were at some sort of Little League thing in Agawam. Alberts, McCabe's, all you people were there. So, like, just know that there will be no life as normal is over. I said it right. Thank you, Mark S. Mark S. Meet Helly S. Mark S, to be not confused with Mark. Who's the Mark in Severance? Why can't I think of his last initial? Mark who? Which Mark is it from Severance? You guys tell me. Except Chris actually did unalive someone. Yes, he was involved in a hit and run car accident in the 90s. He killed a exchange student named Peter Berger. He fled the scene, turned himself in 30 hours later. We don't know if it was a DUI because he didn't turn himself into 30 hours later. Mark S. Thank you, Mark S. Not to be confused with Mark in chat. Wait, Mark S is also Mark S? Wait. Oh, maybe that's where he got his name from. I get. Okay, say his name, Peter Berger. Chris Albert killed an exchange student by the name of Peter Berger in the 90s in a hit and run car accident. That was actually a hit and run car accident. Chris Albert fled the scene, turned himself in with his attorney something like 30 hours later. His attorney was Judge Beverly Cannoni's brother. That might shock you if you did not know that. But Chris Albert's attorney was Judge Cannoni's brother. Last name is Prescott. Did he do 6 months in jail or less than 6 months in jail? Yeah, he was an exchange student from overseas. Yes. Okay. That is true. It's true. Chris owns D&E Pizza, a restaurant in Canton, Mass. Chris testified that on at least 3 occasions, Kearney traveled to Canton and stood outside of D&E Pizza with signs accusing Chris of being part of the conspiracy to cover up O'Keefe's death. Yes, he did. It was 6 months that he did, James, right? Okay, cool. Yes, I did see the parade. Yes, and we're going to play that. So let me star that comment for later because I have the video. We're going to play it. Marcy was marching today in the Memorial Day parade, and somebody said free Karen Reed. So yeah, I'm going to play that for you guys in a bit. Thank you, Kelly, for telling me that so that we can go back and cover that. The drunk cop that left his gun somewhere that night, MM wants to know, well, that was Kevin Albert, another one of the Albert brothers, and he, I think, he got a summer off. And he left his gun in Proctor's car because they were out, allegedly on the Cape after the John O'Keefe murder. And was like, dude, where's my gun? Proctor and Kevin Albert went out, got hammered on the Cape. They were allegedly working on some cold case. And then the next day, these messages surfaced where Kevin Albert was like, dude, where's my gun? I lost my gun and my badge. And Proctor was like, dude, I found your badge in the patrol car we were driving in the center console, but like, where do you mean? I don't know where your gun is. And Kevin Albert said to Proctor, oh, dude, can you leave my badge in my mailbox? Yeah, they were working on a cold case. Yep. So he got the summer off. And did he get like a couple of vacation days pulled? Yeah, we have shows on that too. If you guys need some content to watch until tomorrow, I've got hundreds of hours on this case, on the Karen Reed case, all of the pretrial stuff, all the Proctor stuff, it's all there. You just got to go find it. It's like a treasure hunt. Back to the document. Chris owns D&E Pizza, a restaurant in Canton, Massachusetts. Chris testified that on at least 3 occasions, Kearney traveled to Canton and stood outside D&E Pizza with signs, accusing Chris of being part of the conspiracy to cover up O'Keefe's death. Footnote 13, which says, the first time Kearney went to D&E Pizza, he entered the restaurant while filming. Grand jury transcript, December 14th, 2023, page 10. Chris politely asked him to leave, but Kearney wouldn't leave at first. He started asking Chris questions. Chris just told him he wasn't interested in answering any questions and asked him to leave, and then he left. And that was the grand jury transcript, December 14th, 2023, page 10. On one of these occasions, Kearney, his cameraman, and some of his followers showed up with signs and proceeded to yell at oncoming traffic that Chris and his son Colin are murderers and that D&E Pizza serve blood in their pizza. Footnote 14. The grand jury saw a video recording of Kearney standing outside D&E Pizza yelling, "Chicken Parm Charlie, king of the mediocre chicken parm. Would not recommend it. Comes with a side of murder. Extra blood in there. Yikes, not good. And that's the grand jury exhibit entitled Kearney Outside D&E 2. While this was happening, Chris testified that people called D&E Pizza to order a mediocre chicken parm, laugh, and then hang up. Grand jury transcript, December 14th, 2023, page 13. Does anybody remember the Jerky Boys? I'm dating myself because I had Jerky Boys on cassette tape, and the Jerky Boys would do like phony phone calls, and they would hang up, and they would be like, I forget, like, I'm gonna knock you upside head. I'm gonna knock you upside your head with a wrench or something like. Do you remember that, Jerky Boys? Oh my God, Jerky Boys was so hilarious. It was like, I fell down the stairs and I lost my shoes. My shoes came off, which kind of reminds me of this case too, because, John O'Keefe's shoe came off. So he obviously must have been hit by a car, according to Buchanan. Yeah, the best one was the Roofers. Oh my God, I have to refresh my recollection on the Jerky Boys. And I don't know if I can even find the Jerky Boys like old tape, but we had it on cassette. I mean, that's how far back these phony phone calls go. You can't make phony phone calls anymore because, caller ID, unless you dial whatever it is, star 67 or star 60 something to block your number. But here we are. Felony witness intimidation charges, these are. At one point, Kearney stops what he's saying, turns around to see an elderly woman getting into her vehicle, points at D&E Pizza, and then proceeds to tell her, don't get the pizza. It's not good. You won't like it. I'm telling you, it's not good. Because the guy, he killed the man. They killed the man. Maybe a couple, actually. Grand jury transcript, December 14th, 2023. Oh, all of the Jerky Boy calls are on YouTube. Oh, that's great. It's Kindergarten Cop. I'm going to have to. Frank Rizzo. That's what it was. My name is Frank Rizzo. Yeah, Mark. Yes. My name is Frank Rizzo. Oh my God. Miss Jessica says that Jason Smith introduced her to the Jerky Boys. I know. It was a thing and it was on cassette tape and you had to like have somebody make a tape. Get Brett Weir, I said. Yeah, the turtle, get Brett Weir. I said, get Brett Weir. Oh my God. I'm going to have to refresh my recollection on it and then we'll have like a whole show on it because so good. So good. It was classic, like old school comedy, phony phone calls, but funny, really funny. And you had to have somebody make you a cassette tape from a tape to tape player. So yeah, the old AV squad, Franklin Rizzo, he's looking for paint work. Yeah. Oh my God. So funny. Right. All right. I digress as usual. On another occasion, Kearney and approximately 30 of his followers stood outside D&E Pizza from 4 p.m. until 7 p.m., the busiest time of day. Grand jury transcript, December 14th, 2023, page 12. Again, Kearney and his followers were holding signs calling Chris and Colin murderers. But I mean, in all fairness, like truth is a complete defense, right? And Chris really did kill someone. It wasn't John O'Keefe, but he really did kill Peter Berger, right? I mean, maybe it wasn't like, well, I mean, it wasn't murder, but it was like a drunk. I'm not even saying it was drunk driving. It was a car accident, a hit and run. But he did kill a man. I mean, there's truth in that. While protesting, Kearney approached customers as they left D&E Pizza and asked them why they would give money to that murderer. Grand jury transcript, December 14th, 2023. Chris testified that Kearney's actions made him feel uneasy and unsettled. Grand jury transcript, December 14th, 2023, page 13. He further testified that his business has greatly suffered due to Kearney's actions. Grand jury transcript, December 14th, 2023, page 15. Chris is also a member of Canton Select Board. I'm going to break for a moment to tell you that the Canton Select Board is the boss of, correct me if I'm wrong, is the boss. Thank you, Mitchell. Mitchell says, Melanie, your digressions are much better than this document. Thank you. Protesting during the busiest time of day, says Michael. Maybe he should protest when they're closed. Oh, wait, he did. And they filed charges about that as well. Yes. For those of you who don't know, he also has felony window intimidation charges, actually. Window intimidation charges. Those are additional charges, which are also in the playlist that is linked below this video. The Canton Select Board is the boss of the Canton PD. And we'll have to get into that about the illegal wiretapping, and that's a whole separate issue. And Helena Rafferty announcing her retirement or her resignation or wherever she's going. I have no idea. She's the chief of the Canton PD. She's leaving because Better sent her a letter that she should be prosecuting Chris Albert for illegally wiretapping people who sit on the bench outside of D&E Pizza because they're not allowed to. It's a two-party consent state, and you're not allowed to. If you have surveillance cameras, you can't also record audio. What's happened with that? Anything? Has anything happened? I don't know. I don't think so. One evening, Kearney showed up at a select board's meeting with his followers. While there, followers like he's like David Koresh. While there, Kearney stood close to Chris and came within 2 feet of Chris's ear while holding signs about what a terrible person Chris is, and on a few occasions stuck his middle finger within 1.5 to 2 feet away from Chris's face. Oh well, I mean, you add that to the mix. Grand jury transcript, December 14th, 2023, page 14. After the meeting ended, Kearney and his followers chased Chris to his car and surrounded his car, while Kearney told followers to keep Chris from leaving. Grand jury transcript, December 14th, 2023, pages 14 and 15. Well, do they have video of that? A police officer needed to intervene in order for Chris to leave. Grand jury transcript, December 14th, 2023, page 15. Chris testified that every day is a nightmare for him and his family. Grand jury transcript, December 14th, 2023, page 18. Chris recalled that on numerous occasions, Kearney has said that if Chris and Colin come clean, then he and his followers will stop bothering them and leave them alone. That is the transcript from December 14th, 2023, page 22. Julie Albert is married to Chris Albert and is Colin Albert's mother. Kearney streamed himself as he called Julie's cell phone. While the phone is ringing, Kearney states he knows the Alberts are watching right now. Grand jury exhibit episode 590, call to Julie Albert. When Julie did not answer, Kearney left her a voicemail stating the following. Just calling to ask you a few questions. I saw you at the town at the board. Notice how they're like putting every and in here, but here we go. That's how I'm going to read it. I saw you at the town at the Board of Selectmen meeting a few weeks ago. You looked great and extremely happy in the front row and extremely comfortable, like you wanted to be there. I just wanted to ask you a couple of questions. I'm reading a police report right now from February 10th of 2022 when Michael Proctor says he interviewed you and introduced himself for the first time, which confuses me a little bit because it seems like your family has known him for quite some time. I was wondering how your son Colin, who was at 34 Fairview Road the night that John O'Keefe was murdered, ended up in the wedding party with Trooper Proctor and Trooper Proctor's sister before he was actually a trooper. And I want to know how you guys met. Did you guys just forget about each other over the time that you had to be reintroduced again? But what I would really like to know is if you were in the Canton High School class in 1994, how the hell did Jen McCabe win Best Looking? Were they using Dominion voting machines? Like, how does that happen? And how does that hurt your self-esteem to know that you were in the same graduating class as Jennifer McCabe and she got Best Looking? Like, how do you cope with that? Do you need therapy? That has to hurt your feelings, right? Because that would just devastate me if I lost to horse face. So give me a call back when you get this and we'll talk soon. Bye. Colin Albert is Chris and Julie Albert's son. Colin is a witness in the Reed case. Footnote 15, which says, while Reed, O'Keefe, and others were at bars in Canton, Colin was at 34 Fairview Road with some of his family members. Colin, however, left 34 Fairview Road before Reed, O'Keefe, and others arrived. Well, that's a fact in contention, but I guess for purposes of this motion, the judge is taking that as fact. At the time of O'Keefe's death, Colin was 18 years old. Oh, he was 18? Okay, I didn't know that. I thought he was younger than 18, and that's why everyone was screaming that he was a minor. So this judge says Colin, at the time of John O'Keefe's murder, was 18 years old. Specifically pertaining to Colin, or Colin, depending on who you listen to, because Cosgrove, the special prosecutor who was hired by the Norfolk County District Attorney's Office to persecute Aidan Kearney, because they have a conflict. See, they had to hire this guy Cosgrove, who happens to be a retired judge from Norfolk Superior Court. Go figure, right? Isn't he? he calls him Colin. He doesn't understand that it's pronounced Colin. And so every time in open court, Cosgrove gets up and he's, I don't know, he's an older man. And he says Colin, like as in Colin Powell, I guess. But Colin Powell does spell his name the same way. So I can see the confusion. However, everyone else calls him Colin, and everyone else who's familiar with this case knows that his name is Colin, but Cosgrove, go figure, calls him Colin the same way Hank Brennan calls Bobby Scissorhands Alisi, as in Khaleesi from Game of Thrones, but that's a whole other story. I digress again. So according to this document, Colin was 18 years old at the time of John O'Keefe's death. Specifically pertaining to Colin, Detective Lieutenant Tully introduced the following videos that were filmed by Kearney. Episode 595, Ken Kick Colin Albert's Ass. Footnote number 16, which says in this video, Kearney calls Chris Albert a punk ass bitch and then says, "You think I'm scared of your effing P son, Colin? Oh, I can't wait to see Colin. I'm going to have a lot of questions for Colin. And something tells me he won't be able to control his temper like you did. He can get some. He can get some too. I'm not afraid of your stupid son. Believe me, I could kick the S out of your stupid son." Obviously, I am not saying the words that are in this document for some of my viewers' virgin ears and their children. So you don't have to put earmuffs on, kids. You can listen. Episode 596, Call to Colin Albert. Episode 616, Trying to Destroy Colin's Life. Footnote 17. In the video, Kearney stated he is trying to put Colin in jail and destroy his life. And episode 623, Colin Albert. Grand jury transcript, December 5th, 2023, pages 60 to 61. I just want to point out here that there are people who are actually like government officials who are trying to put Karen Reed in jail and destroy her life without any evidence of a motor vehicle accident. I'm just going to point that out, but that is actually really happening in the same courthouse, and we have all been watching it together. And if Judson Welcher doesn't come in here and pull some rabbit out of a hat, I don't know what's going to happen with the Commonwealth's case, because so far I haven't seen any evidence that John O'Keefe was hit by a car or that a car hit John O'Keefe. So the big Hail Mary is coming tomorrow with the testimony of Judson Welcher. We'll be here for it tomorrow at 9 a.m. When I end this video later, because we're not quite done yet, it will teleport you over to the morning stream so that you can hit the bell and remind yourself to come back with me tomorrow morning, because you're not going to want to miss it. Colin is a football player at Bridgewater State University. Colin recalled Kearney saying that he was going to show up at Colin's practices and games until Colin quit the football team. Grand jury transcript, December 5th, 2023, page 66. Colin, scared for himself and not wanting to put his team through that, did not play football during the 2023 season. That is found in the grand jury transcript, December 5th, 2023, page 67. While live streaming, Kearney called Colin's cell phone and broadcasted his cell phone number. When the call went to voicemail, Kearney left the following message. Quote, "Exactly. Marcy said that Colin was not in the house, May Cronin. You're right." In that August 2023 hostage video that we've watched so many times, but you really can't watch it enough. It's only 5 minutes long and it is comedy gold. Okay, here's the following message. Quote, "Yo, Colin, it's Turtleboy from them Advantage Boys. Bang, 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 bang. Yo, we'll F any of you dogs up. Yo, you challenge my boys, them Advantage Boys, to a fight, dog. And we all about that life, son. We about that life, and we from Sharon, son. Yo, y'all Canton biatches ain't even hard, yo. Us Sharon biatches are Advantage Boys. Nobody be effing with us and S dog. So, yo, call me back." No, but seriously, it's Aidan Kearney from Turtleboy Daily News. I just want to know, were you the one who killed John O'Keefe, or was that your Uncle Brian? Who hit him first? Who hit him with the back of the head with the thing? Are you worried that you're going to go to jail for the rest of your life and that you won't be able to play football at Bridgewater State next year? Love to have a conversation with you. Your dad kicked me out of your pizza shop and I didn't get to eat his mediocre chicken parm. So I just wanted to know if you could talk to me about that. And maybe you could maybe you and I could go for a ride. We could find them Advantage Boys. Bang, bang. I don't know. So give me a call when you get this. Bye. Grand jury exhibit, episode 596, Call to Colin Albert. After leaving this message, Kearney spoke to his followers on the same video and said, "You heard the number, so you can replay it if you want to hear the number. That's Colin's number." Grand jury exhibit episode 596 called Colin Albert. As discussed above, Jennifer McCabe and Matt McCabe are witnesses in the Reed case. In addition to the video footage of the rally, Detective Lieutenant Tully also introduced the following videos that were filmed by Kearney. Confronting Jen McCabe at Lacrosse game, footnote 18, which says, pursuant to the Commonwealth's brief, this title was assigned by the Commonwealth, and the clip actually comes from a Turtleboy live broadcast entitled, Asking Jennifer McCabe That Question. Does she know the answer? But they decided to retitle Turtleboy's work. He's not going to like that. Episode 594, McCabe's residence. Episode 585, confronting McCabe outside Norfolk Superior. Episode 619, need to go to McCabe's soccer games again. Episode 623, Jen McCabe. Footnote number 19, which says in episode 623, Jen McCabe, Kearney states, so Jen McCabe didn't go to court. Right. And because rightfully so, we have shamed her into no longer going to court. But a turtle rider, I don't know if this was yesterday or when, but a turtle rider went to her house, which, by the way, 100% fair game. Enough of this, like, oh, be nice to them. You shouldn't go to their house. No, you should. You should be peaceful about it. You have a right to do that. And these people, every day they're free, is a disgrace. And that is from the grand jury transcript, December 5th, 2023, pages 10 to 15, and episode 613, not leaving second generation out of it. Grand jury transcript, December 19th, 2023, page 6. While Jennifer, Matt, and their younger daughters were watching their older daughter's lacrosse game, footnote 20, Kearney came running over to them and yelled in Jen's face, asking her whether she thought she could outsmart Karen Reed and if she was worried about what will happen to her family when she goes to jail. Footnote 21. Okay, so footnote 20 says about the lacrosse game. In episode 62, footnote 20. This was the playoff game, their daughter's last high school game ever. Grand jury transcript, December 5th, 2023, page 22. All right. I just want to say I'm not condoning what he's doing here. And I think it's, it's not nice. Question is it illegal under the statute? And should the indictments be dismissed? Because if they're not dismissed, they're going to trial. And the trial is going to be something. So footnote 21 says Kearney videotaped the entire encounter, which was played for the grand jury and corroborated Jennifer's recollection of the encounter. So again, his self-snitching videos are what they're using as evidence to either dismiss or not dismiss these indictments. You follow? After footnote 21, that is grand jury transcript, December 5th, 2023, page 21. As Kearney left the game, he films himself yelling that Jennifer and Matt are cop killers and that he cannot wait until they go to jail. Grand jury exhibit confronting Jen McCabe at lacrosse game. After the game ended, Jennifer recalled that she and Matt went straight to their vehicle because she didn't want her daughters or the other children to be harassed or videotaped. Footnote 22, which says, after this altercation, Kearney wrote a blog post where he stated, Jen and Matt McCabe do not deserve to live a normal life and pretend that they aren't involved in murdering a Boston police officer. Grand jury transcript, December 5th, 2023, page 39. And in a subsequent YouTube video, Kearney said, I went to her kid's lacrosse game and made a scene there and got kicked out because they kept calling her a cop killer. Grand jury transcript, December 5th, 2023, page 40. As Kearney left the game, he films himself yelling. Oh, wait. Sorry, we are here. Matt testified that Kearney's unexpected appearance at the lacrosse game made him sad because it was his oldest daughter's last high school lacrosse game ever, and that he felt uneasy because he was unsure if a physical altercation could occur. Grand jury transcript, December 5th, 2023, pages 44 to 45. On September 20th, 2023, Kearney live streamed episode 615, Not Leaving Second Generation Out of It, on YouTube. In that video, Kearney is quoted as saying, "I'm saying this as a matter of fact that Jen McCabe participated in the killing and planning to kill and cover up of the murder of John O'Keefe. I'm saying that. That is not my opinion." Grand jury transcript, December 5th, 2023, pages 12 to 13. Portrayed in that video is a sign on Jennifer McCabe's sister's lawn in Canton. With the sign displayed, Kearney states, Jennifer McCabe's sister's lawn. Is that the 34 Fairview lawn or her other sister? She has other sisters, right? I don't know. All right. With that sign displayed, Kearney states, "You killed John O'Keefe, you worthless piles of S. I'm going to find you, mother effer. I'm going to find you. You know that. You want to effing dance? We can effing dance. I didn't know you before this. I thought you were Jen McCabe's lesbian sister or some S. I didn't know S about you. Now we know about your son, Tommy. Tommy's lacrosse coach, I believe, at Canton High, right? Yeah, whoa. We can talk about Tommy too. We can pay Tommy a visit. We can pay Tommy a visit too. We're going after the whole effing deal now, all of it. Allie McCabe, she can get it too. They can all get it. We've left the second generation out of this for a bit, but that's over, except for Brian Albert Jr., because he looks functionally hard. But besides him, the rest of them, they're all going to get it. They're all going to get it. Caitlin Albert, we got some questions for you. Show up at another Bridgewater State football game. I dare you. Daddy's coming to town. These people make me sick. These people make me sick." Grand jury exhibit, episode 615, not leaving the second generation out of it. On another occasion, after a hearing in the Reed case, Kearney followed Jennifer and Matt as they walked from Norfolk County Superior Court to their vehicle and repeatedly called them cop killers. Grand jury transcript, December 5th, 2023, page 14. After this altercation, Kearney posted a video where he provides the following commentary and interaction. "Like Matt, I called your wife a C-word, dude. I called her a cop killer in the middle of Dedham. That's your woman, right? You married her, in S. She bore your children. What are you? I disrespected you in the worst way, the worst possible way a man can be disrespected. I disrespected your wife in public. And boy, am I looking to do it again. And it's going to be much worse next time. I'm going to disrespect the F out of her over and over and over again. And you, I guess you're going to just stand there and do nothing because that's the kind of Pete you are, dude." Grand jury exhibit 585. Episode 585, confronting McCabe's outside Norfolk Superior. On a different occasion, after Jennifer and Matt dropped their kids off at camp, Kearney went to the McCabe residence and filmed into their home. Grand jury transcript, December 5th, 2023. Kearney recorded himself get out of his vehicle, walk up to the McCabe's driveway, walkway, and their front steps before ringing the McCabe's doorbell. Kearney later broadcasted it while offering commentary describing his satisfaction that the McCabe's front door was open, saying, "Oh, S, the door's open. She left the door open. Well, that's going to make this a lot easier. She can't close the door on me because she's not going to want to come near me." Grand jury exhibit, episode 594, McCabe residence. Jennifer testified that she's afraid to leave her home because people take photos of her, Matt, and the children when they're in public. Grand jury transcript, December 5th, 2023, page 24. Jennifer recalled that when she was in Aruba for her daughter's senior year trip, an unknown individual took a photo of her and her daughters. They go to Aruba too? An unknown individual took a photo of her and her daughter. How do we know that that has anything to do with Kearney? Yeah, she was in Aruba too, I guess. As discussed above, was she with the Sullivan sisters? As discussed above, Trooper Proctor is the lead investigator in the Reed case. While recording one of his videos, Kearney called Trooper Proctor's work cell phone, publicly shared that phone number, and left a voicemail. Kearney's voicemail contained the following message, quote, James Lynch points out, if being a jerk was a crime, half the state would be in jail. I guess everybody goes to Aruba, right? It is very nasty. I agree with you, Mimi. It's very nasty. Quote, hi, Trooper Proctor. This is award-winning journalist Aidan Kearney calling. I'm calling to talk to you. I do have some questions about you. I have a lot of questions, actually. For starters, why didn't you tell anyone before doing the investigation that you're good friends with the Albert family? Why did you, in your reports, say that you were introduced to Chris Albert on February 10th when you had known him for more than a decade prior to that? Why did you lie about what time you towed Karen Reed's car? Why did you intentionally misspell the names of several key witnesses in your report? And I'm just wondering about all of those things. And maybe you and I can meet up for coffee, because boy, do I have a lot of questions for you. When you were inside Fairview Road that morning rather, why did you stay there for 4.5 hours? And what did you guys talk about and do? And why were you descending stairs with John O'Keefe's phone in your pocket? So give me a call back, man. I feel like you and I have a lot of catching up to do. I talk about you a lot, and I feel like I know you pretty well at this point. I know which year you graduated from the academy. I know you're out in West Brookfield for a while. I know some people that you know. So give me a call back when you get this. Now that I have your number, and everybody watching has your phone number, which again is, and he publishes the phone number. Grand jury transcript, December 14th, 2023, page 37 to 39. I'm sure he's probably changed his phone number by then. Yeah. After Kearney disseminated Trooper Proctor's phone number, Trooper Proctor immediately received unknown phone calls, scathing voicemails, and text messages, to the point that he had to shut off his phone and change his number. Oh, he did change his number. Okay, so we don't have to worry about that. I didn't redact it because, like I said, I hadn't read this whole thing yet. Grand jury transcript, December 14th, page 39. Elizabeth Proctor is married to Trooper Proctor. Detective Lieutenant Tully testified that Kearney disseminated Elizabeth's employment information and encouraged his followers to post negative comments about Elizabeth on her employer's social media pages, which they did. Grand jury transcript, December 14th, 2023, pages 25 to 26. Shortly thereafter, while live streaming, Kearney called Elizabeth's cell phone, publicly shared her phone number, and left a voicemail. Grand jury transcript, December 14th, 2023, page 23. In his voicemail, Kearney said the following. Yeah, Mariko says, I appreciate Aidan Kearney's passion for and devotion to journalism. I just am iffy a confrontation at any places that include the children. I think we can agree on that. Caroline thanks me for covering this. I can't quit now. I've already covered all the hearings and all of the motion papers. I can't not do the decision, right? Just because it gives a lot of detail and about things that a lot of people might not know allegedly happened, according to this judge. Here's the voicemail to Elizabeth Proctor. Hi, Elizabeth. This is Aidan Kearney calling you back from Turtleboy. I just wanted to see how your day at work went today, if it went well. I noticed that your employer took down their social media pages within minutes of the blog I published about your recent behavior. And I just want to see what, is it awkward? Were you afraid to go in? Just tell me about your day and why, because that's the best part. I don't understand it. I'm sorry. That's the part I don't understand, is that you seem to be okay with calling other people's workplaces and interfering with their ability to make a living for themselves. But when it happens to you, maybe it's not as fun. Maybe it's not as fun. Do you like that? That's what I want to know. Did you like that? Because you've been doing that to a lot of other people. And do you think it's fair that it happened to you, dear? Do you regret it? Do you regret it? And what's your S-bag husband up to right now? Are you going to visit him in prison? Do you think they'll have conjugal visits? Give me a call back when you get this and we can chat some more. Bye, girl. That is Grand Jury Exhibit 580, Elizabeth Proctor. June 27th, 2023, while Elizabeth was home alone with her 2 young children, footnote 23, Kearney and one of his followers unexpectedly showed up at the Proctor residence. Kearney filmed himself as he rang their Ring doorbell. Footnote 23 says, Elizabeth and Michael Proctor's children are aged 2 and 4. They were then, or they are now? Because this was 2023, I think. Yeah, June of 2023. Elizabeth recalled, so this is a Turtleboy video ring cameras. This must be their actual ring footage, the Proctor's ring footage. Elizabeth recalled how Kearney posted a video where he said Elizabeth's husband is going to jail and that her children were going to call Kearney daddy. Grand jury transcript, December 14th, 2023, page 31. Elizabeth testified that Kearney, quote, has tried everything in his power to try to destroy her and her family's lives and reputations, and that he threatened to harm her children to take her children. Grand jury transcript, December 14th, 2023, page 29. Kearney's actions make it difficult for Elizabeth to go out in public because she does not know if someone's going to come up to her, if they're going to say something, and they're going to, target her children, since he's put that out there. So it's a real fear every day they go out. Grand jury transcript, December 14th, 2023, page 34. Sergeant Yuri Buchanan is a Massachusetts State Police sergeant assigned to the Norfolk County DA's office in the homicide unit as a supervisor. Sergeant Buchanan was involved in the investigation of O'Keefe's death and is a witness in the Reed case. Notice that it doesn't say he was the lead investigator because Judge Doolin said Proctor was the lead investigator. On or about July 25th, 2023, Kearney and Sergeant Buchanan were both present at a motion hearing for the Reed case at Norfolk County Superior Court. During a recess, Sergeant Buchanan went to the men's restroom where he used the leftmost urinal of 3. As he was using the urinal, Kearney entered, went to the rightmost urinal, and asked Sergeant Buchanan questions regarding Trooper Proctor and the investigation. Sergeant Buchanan did not respond to Kearney. Unbeknownst to Sergeant Buchanan, Kearney had photographed him and recorded the encounter. On September 15th of 2023, there was a large crowd outside of the Norfolk Superior Courthouse. As Sergeant Buchanan was entering the courthouse, Kearney used a bullhorn to direct the crowd's attention to Sergeant Buchanan, prompting the crowd to chant and yell at him. On the same day as Sergeant Buchanan was leaving the courthouse, Kearney approached him and started to ask him questions, recording the interaction. Sergeant Buchanan testified that Kearney was utilizing a bullhorn to badger him with insults. Grand jury transcript, December 14th, 2023, page 52. Kearney was part of a crowd of approximately 12 to 20 people who surrounded Sergeant Buchanan's cruiser. As Sergeant Buchanan entered his cruiser, Kearney told him that he's Michael Proctor's little biatch and proceeded to call him an effing pig and an effing disgrace. And jury exhibit Sergeant Buchanan outside Norfolk Superior. In addition to these events, Kearney has also posted photographs of Sergeant Buchanan's family on his social media platforms. Sergeant Buchanan testified that when he's off the clock, he's constantly being photographed in public. Sergeant Buchanan recalled that when he and his brother were leaving a Bruins game, 2 individuals followed him and started to chant that he's the shady cop from Turtleboy. Grand jury transcript, December 14th, 2023, page 54. On December 19th of 2023, the grand jury heard testimony from Detective Lieutenant Tully and Lieutenant John Fanning regarding Kearney's involvement with Janelle Webb, an Avon police dispatcher. Footnote 24, which reads, the 3 indictments under General Law 274, Section 7 are related to Kearney's involvement with Janelle Webb. Kearney would communicate with Webb through his social media account under his name and the alias Clarence Emerson Woods. One evening, while Trooper Proctor and Lieutenant Fanning were working, Jennifer McCabe went to the Proctor residence to see Elizabeth. Somehow, Kearney learned that there were vehicles that did not belong to the Proctors parked outside of the Proctor residence. Lieutenant Fanning came across a post by Kearney in which he states he had the plates run and that the vehicles belonged to Trooper Proctor, Elizabeth Proctor, and Jennifer McCabe. Well, here's what I'm breaking from the document for a second to say. Is Lieutenant Fanning like the assigned big tattletale of the MSP? Because he's the one who had a guy tell a guy who told a guy who told Fanning, who told a guy who told a court officer that one of the Karen Reed jurors who was visibly pro Karen Reed in her facial expressions had been at the American Legion Hall a month prior. And 10 minutes prior to closing arguments, that juror was dismissed based on the hearsay allegations from Fanning to a court officer, maybe that this woman had been at the American Legion Hall. So Fanning seems to be the guy who's like, I don't know, is he following people? I don't know if he's following people, but how would anybody know who this juror was at the American Legion Hall? Isn't it like members only over there? Master of Whispers Fanning, says Lyndon Martingale. Fanning's out there scouring, I guess, Turtleboy's posts. Because whatever they do, whatever they had to do to incarcerate him, they did. And we've been over the other motions with regard to the other case involving Lindsay Gattani and the text messaging that went on between Tully. Why am I drawing a blank right now? Tully, was it Cosgrove involved in those text messages? Tully or Ken Mello? It was Ken Mello, because Ken Mello is now out. He's MIA. Cosgrove took over for Mello because they had to hire a special prosecutor to prosecute Aidan Kearney. Tully, Mello, Not So Confidential Informant, Masshole Mafia, Kate Peter, and Lizzie Gattani. There's a text message thread between the four of them in which they are trying to perhaps ensnare Aidan Kearney into violating his bail conditions on these cases. And that actually did happen. And that is what led to his incarceration of 60 days. They wanted to keep him in there for 90 days, but I guess they realized that 90 days was 90 days was unconstitutional. And so they let him out after 60, right? Turtleboy Live is here, and I can't highlight it, but he says, they murdered a cop, frame an innocent woman, set me up to go to jail, and people think I'm the one who crossed the line. Disgusting. Kai Y Mai says they literally just handed $75,000 to Mello for doing nothing. Yeah, and they actually also are handing defense attorney Hank Brennan, already have given him $250,000 at $250 an hour to persecute Karen Reed, and it's going to go up because that did not include his trial prep and all of his days of trial, however long this mishigas of a case goes on for. In my estimation, he's going to be paid close to $1 million by the time this is all over, if not more, right? So Lieutenant Fanning came across a post by Kearney in which he states he had the plates run and that the vehicles belonged to Trooper Proctor, Elizabeth Proctor, and Jennifer McCabe. Lieutenant Fanning testified that running a plate is a phrase law enforcement uses, which means that a license plate was queried using a system that is available to law enforcement. Yeah, you know who also it's available to? Just about every law firm out there. If you have an account with the DMV, you can run plates, for a fee. So it's not just available to law enforcement. Yeah, Microdot says his crime was exposing the state, and Robin G wants a tax refund. And Mindy says our tax dollars paying for expert witnesses with associate's degrees. And there's no shade to associate's degrees. It's fine. You can be an expert with an associate's degree. What you can't do is lie about it. You can't lie and say that you have a bachelor's and then have 4 different CVs that are all in conflict with each other. You can't do that. You can't lie about your credentials because then everything else that you say on the stand can be disregarded. If the jury finds you lied about one thing, were you lying then or are you lying now? Were you pursuing your degree? Are you still pursuing your degree or did you give up? Did you get your degree in 2018? Did you get the degree that doesn't even exist from the university? I mean, if you're going to fake your resume, at least find a degree that the University of Alabama actually offers. How about that? How about that? That's just, a pro tip. This led Lieutenant Fanning to believe that a police officer or dispatcher improperly used that system. Really? Because it couldn't have been a lawyer's office? Okay. Although, what a crackerjack detective he is. This led Lieutenant Fanning to believe, although there is not a criminal statute that punishes individuals for improperly utilizing the system, there is a code of Massachusetts regulations that prohibits such conduct. Lieutenant Fanning audited the system, which revealed that Webb had ran the 3 license plates within minutes of each other and within a short time of Kearney making the post. I guess I don't know if I know this, but was Janelle Webb fired for doing this? Like, I think her name is Michelle Littlefield was, for giving him some documents regarding the Chris Albert restraining order that wasn't granted, which again, public record. Anybody, you could pay couldn't you pay an internet company? You could give them a plate and you could pay them to run it for you and you could just do that online. You don't need somebody in law enforcement to do that for you. But here's Fanning working overtime to crack the case. On or about September 27th, 2023, Webb was interviewed by Lieutenant Fanning. Oh, yeah, because they're going to really do more of an investigation on this than they did on the murder of a Boston police officer, John O'Keefe. Ridiculous. Webb was interviewed by Lieutenant Fanning, where she stated Kearney, through his Clarence Emerson Woods account, messaged her on Facebook requesting that she run the license plates for the vehicles parked outside of the Proctor residence. Footnote 25. This testimony was corroborated by screenshots of messages between Webb and Kearney. Grand jury transcript, December 19th, 2023. So I guess Janelle Webb provided them with screenshots of text messages. She resigned. She was not fired. Thank you, Lindsay. Thank you, Lindsay. They did more of an investigation on this than they did on John O'Keefe, and they did more of an investigation on Richard Schiffer and the rubber duckies that he was putting around town with stickers on them than they did for the murder of a Boston police officer, fellow brother in blue. That police report for Richard Schiffer, and if you haven't seen that, it's also on the playlist somewhere. I think it's called What the Duck. That police report was 36 pages long. That is longer than any of the reports in the murder of John O'Keefe. It's disgraceful. Discussion. In moving to dismiss the indictments against him, Kearney raises several arguments. First, Kearney asserts that General Law 268, Section 13A and 13B criminalizes protected speech in violation of the First Amendment and Article 16 of the Massachusetts Declaration of Rights. In so doing, Kearney argues Section 13A is unconstitutional on its face and as applied to him, and 13B is unconstitutional as applied to him. Second, as to all 16 indictments, he argues that the Commonwealth failed to establish probable cause to support the indictments. Third, he contends that the integrity of the grand jury proceedings were impaired. The court discusses each of these arguments below. Okay. Roman 1, the defendant's constitutional challenge. Try and save your comments for later because it's hard for me to watch the chat when I'm reading, but thank you. Thank you for having questions. Well, I mean, not your comments, but your questions. But, keep your comments respectful because, that's what we try and do here anyway. I have it set to 24-hour subscribers. Should I make it more? Mods, are you okay in there? I see a lot of things going on. Oh my God, Kathy's here from Gossip, Rumor, and Innuendo. What? Who loves Kathy? We all love Kathy. Kathy, is that you or is it someone impersonating you? We love you, Kathy. Yay, Kathy. Kathy's here. If you don't follow Gossip, Rumor, and Innuendo, go do it. She will wake you up every day with a laugh. She has not been covering Karen Reed or Aidan Kearney, and you really don't even need to ask her why. because you are respectful. I know you're respectful. You're respectful. Some of you are, some of you aren't. It is. It's Kathy. Yay, Kathy. Kathy doesn't want to be attacked like the rest of us who have been, in the first line of fire here. Somebody wrote a comment. Well, never. I'm not even going to address that. But thank you. I love you, Kathy. Love you, girl. We got to catch up. All right, moving on. The defendant's constitutional challenge. The First Amendment, applicable to the states through the 14th Amendment, prohibits the enactment of laws abridging the freedom of speech. Footnote 26, which states, both the First Amendment to the U.S. Constitution and Article 16 of the Massachusetts Declaration of Rights, as amended by Article 77 of the amendments to the Massachusetts Constitution, generally protect speech from government regulation, citing some other cases. Coincidentally, one of them is Reed v. Gilbert, R-E-E-D. Quoting First Amendment to the U.S. Constitution, the free speech clause is not limited to the spoken or written word, but extends to other expressive conduct. Texas v. Johnson, which is a case from U.S. Supreme Court case from 1989. Generally, the First Amendment means that government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. Citing Ashcroft v. American, the ACLU, U.S. Supreme Court case from 2002. But this principle is not absolute. See Virginia v. Black, U.S. Supreme Court case 2003. The Commonwealth may regulate speech based on its content in two ways. First, the Commonwealth may regulate speech that falls into one of the several historically unprotected areas, such as obscenity, defamation, fraud, incitement, and speech integral to unlawful conduct. See U.S. v. Stevens, 2010. Second, the Commonwealth may regulate otherwise protected speech so long as it satisfies strict scrutiny, citing Reed, R-E-E-D. To satisfy strict scrutiny, the Commonwealth must prove that the restriction furthers a compelling interest and is narrowly tailored to achieve that interest. Footnote number something so tiny that I can't read, but I think it's this one, 26. Both the First Amendment to the U.S. Constitution and Article 16 of the Massachusetts Declaration of Rights, as amended by Article 77 of the amendments to the Massachusetts Constitution, generally protects speech from government regulation. Commonwealth v. Walters, see Massachusetts Coalition for Homeless v. Fall River. You know what? those are quotation marks, not a footnote, because I already read that footnote. Okay. Massachusetts Coalition for the Homeless v. Fall River. Quoting read. Facial challenges. Okay. Big letter A. Facial challenges to GL 268, Section 13A. General Laws 268, Section 13A provide whoever with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing any judge, juror, witness, or court officer in the discharge of his duty, pickets or parades in or near a building housing a court of the Commonwealth, or in or near a building or residence occupied or used by such judge, juror, witness, or court officer shall be punished. Kearney argues General Laws 268-13A is unconstitutional on its face because it is overbroad and encroaches upon non-criminal speech. Specifically, he contends that because General Law 268-13A reaches speech that is neither a true threat nor fighting words, the statute is unconstitutional, both on its face and as applied to him. Footnote 27. Although unclear, it seems Kearney is resting his facial challenge on the notion that the statute violates the First Amendment's overbreadth doctrine because he contends the statute implicates protected speech. Quote, the First Amendment doctrine of substantial overbreadth is predicated on the danger that an overly broad statute, if left in place, may cause persons whose expression is constitutionally protected to refrain from exercising their rights for fear of criminal sanctions. Commonwealth v. Jones. To guard against those harms, the First Amendment's overbreadth doctrine allows an individual whose speech may be constitutionally regulated to argue that a law is unconstitutional because it infringes on the speech of others. I'm not going to read all the citations, but I'm putting them up here so you can go back to them if you want to later. Overbroad laws may deter or chill constitutionally protected speech, and if would-be speakers remain silent, society will lose their contributions to the marketplace of ideas. A statute may be invalidated as overbroad if a substantial number of its applications are unconstitutional, judged in relation to the statute's plainly legitimate sweep. There's a footnote here that says, although unclear, it seems Kearney is resting his facial challenge on the notion the statute violates the First Amendment's overbreadth doctrine because he contends the statute implicates protected speech. Quote, because it destroys some good along with the bad, invalidation for overbreadth is strong medicine that is not to be casually employed. Logically, then, to justify facial invalidation, a statute's unconstitutional applications must be realistic, not fanciful, and their number must be substantially disproportionate to the statute's lawful sweep. The overbreadth claimant bears the burden of demonstrating from the text of the law and from actual fact that substantial overbreadth exists. Whereas here the statute at issue is criminal, it must be scrutinized with particular care. Kearney argues that his picketing activities and statements he made while picketing were protected expression. Therefore, because the Commonwealth indicted him using non-criminal speech, the statute is overbroad. This argument, however, fails to demonstrate that the statute implicates a substantial amount of protected speech. From the plain text of the statute, it is clear that it targets picketing or parading performed with criminal intent. And then they're quoting the actual statute, General Law 268-13A, quote, whoever with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing any judge, juror, witness, or court officer, emphasis added. As the statute requires specific intent on behalf of the individual, it is difficult to imagine what constitutionally protected speech would fall under those statutory prohibitions. Moreover, the mere fact that one can conceive of some impermissible applications of a statute is not sufficient to render it susceptible to an overbreadth challenge. Therefore, because a substantial number of the statute's application will not be unconstitutional, Kearney has not met his burden of demonstrating that GL 268-13A is unconstitutionally overbroad. Okay, so this Judge Doolin is saying that particular statute is not unconstitutional on its face. In his opinion, remember, this is the lowest trial court in Massachusetts. This could be appealed to the SJC, which is the next level of court, first level of appellate court. The court acknowledges that because General Law 268-13A regulates picketing and parading in a traditional public forum, and such expressive conduct is necessarily associated with speech, the statute could implicate protected speech. Even so, Kearney's facial challenge still fails. While Kearney is correct that only, quote, certain well-defined and narrowly limited classes of speech may be constitutionally prohibited, he fatally ignores the notion that the Commonwealth may permissibly regulate constitutionally protected speech and expressive conduct so long as it can demonstrate that the regulation is narrowly tailored to achieve a compelling government interest. Citing a case named Sable, the government may regulate the content of constitutionally protected speech in order to promote a compelling interest if it chooses the least restrictive means to further the articulated interest. And another case called Perry. Government can impose content-based restrictions on communicative activity if the restriction is necessary to serve a compelling state interest and that it is narrowly drawn to achieve that end. For the statute to be narrowly tailored, it must be the least restrictive means to further the articulated interest. The statute cannot be over-inclusive or under-inclusive. It is undisputed that the Commonwealth has a compelling governmental interest in protecting the orderly administration of justice and in assuring that witnesses in criminal proceedings are insulated from harassing, intimidating, and threatening conduct that could deter them from testifying. General Law 268-13A is narrowly tailored to serve that interest. The statute does not categorically prohibit picketing and parading in or near a courthouse or a witness's residence. Rather, it prohibits picketing or parading in or near one of those locations if done with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent to influence a witness. As such, the reach of the statute is narrowed by its intent requirements. In sum, even if the court were to assume that the statute restricts protected speech or expressive conduct, the Commonwealth has satisfied its burden of showing that the restriction does not violate the First Amendment because the restriction is justified by a compelling government interest and is narrowly tailored to serve that interest. Footnote 28, which says, insofar as Kearney is also arguing General Law 268-13B is unconstitutionally overbroad, that argument also fails. General Law 268-13B in pertinent part provides that whoever directly or indirectly, willfully misleads, intimidates, or harasses another person who is a witness or potential witness at any stage of a criminal investigation, grand jury proceeding, trial, or other criminal proceeding of any type with the intent to impede, obstruct, delay, harm, punish, or otherwise interfere thereby, or do so with reckless disregard with such a proceeding shall be punished. While General Law 268-13B arguably regulates speech and expressive conduct based on its content, it too serves the compelling government interest in shielding witnesses from threats, intimidation, and harassment. See Commonwealth v. McCreary from 1998, which states that the purpose of General Law 268-13B is to protect witnesses from being bullied or harried so that they do not become reluctant to testify or give truthful evidence in investigatory or judicial proceedings. The statute is also narrowly tailored to achieve that compelling interest. The statute is limited in scope to individuals who act or speak with the intent to, or with the reckless, I probably should say reckless disregard, but the word disregard is missing, or with the reckless for the fact that it may impede, obstruct, delay, or otherwise interfere with a criminal proceeding. Therefore, General Law 268.13b also satisfies strict scrutiny. We're only on page 22. We need a snack break. You need a snack break? Let's look at some questions now because we're a little more than halfway through this, but we're at page 22. So let's go back to page 22, which is right here. Let me remind myself where I am and take a look at some of the questions. Thank you, Carmel, for becoming a new member. Unless he never sleeps, Marissa J says, watching from Cancun, looking for AJ since you're not here. That's hilarious. Yannetti Solano, where can we get that hat? No, Paris Ray and the Crush, are you here? I'll get the link and I'll link it below the video for you. Okay. Thanks, Yannetti Solano. The Goodmans are here and they gifted a membership. Thanks you. Thanks you guys. I'm Cora, not Chloe. David Reese says Philadelphia is where the Constitution was created. Brennan, the human micropene, thank you for tuning in from Australia, and says, I'm surprised Burgess's CV didn't say he worked at Vandalay Industries. Remember, it's not a lie if you believe it. Oh, so true. Thank you on top for being on top of the super stickers, as always. The last, Ronan, says, new sub to the channel. Cheers, cheers, Ronan. Thanks for joining. Cheryl C. from Canada, around 19 minutes, Brian Albert admits to having a camera on his house. I don't know where, about 19 minutes. Are you talking about in Turtleboy's video? I don't know where they can find that, Cheryl C., but maybe you can put it in the chat. So if anybody wants to find it, they can. You mean 19 minutes into his testimony in the Karen Reed trial? Because that's possible. I know. He said, well, I don't know if he said he had a camera. He said he had one, but he hadn't set it up yet. That's what I recall from his testimony at the Reed trial. Corroborate this, Hank has been hanging out for 11 months. Just email pics of Jen in the Cape this weekend. Yeah, it's not my style to really show those pics, but I think that people can go find them if they want to. But thanks for that. Midnight Mike, Jerky Boys, Terrorists Pizza. Thanks, Mike. You always pick up what I lay down. Shot Gossiper Innuendo is just peeking in. We love you. We love you. Mike from Province, like, sue who? Sue everybody. Yes, that was the Jerky Boys. Everybody, sue everybody. And then Mike, we got a lot of Mike. Midnight Mike gifted 5. So congratulations to the 5 members who were randomly selected through YouTube. Gray Space says none of these video titles are real. Oh, really? They just retitled the videos for their own purposes. Christina Alexander, thanks for becoming a member. Jay Lee, I've watched every moment of every Karen Reed trial, but this is the first I've seen of Aidan's case. I'm surprised it hasn't been more publicly covered. Well, you're in the right place. And I didn't cover it. In fact, when I started covering the Karen Reed case, I intentionally didn't read any Turtleboy because I wanted my own take on it. I didn't want anybody influencing me to look into other places. And what I wanted to do, since I'm a lawyer, is focus on all of the official police reports and all of the stuff and kind of stay away from the drama. But nobody has done more to investigate the Karen Reed case than Aidan Kearney. And, they're prosecuting him on First Amendment type grounds. So I don't know if they're going to appeal this decision, and I'm interested to see. But we've watched the hearings that we could watch that were covered on Zoom and other places. So there's a whole playlist on it. It's below the video, Shaylee. If you're interested, please go watch it. Thank you. Thank you, Mike, for gifting another 5 memberships. And Tumultuous for becoming a member. My degree is pending too. Says, I love your insight for us non-law dogs. Got my mom watching in Florida. Hello. Hello to my degree is pending two's mom watching in Florida. Brian M. This case is a microcosm on obvious misconduct by the authorities, a trickle down of systemic corruption. The DA deserves all scrutiny. 100%. I agree with you. JT says, why were Jen and Liz Proctor meeting in 2023? She questioned about that? Was she questioned about that on the stand? I think she was, wasn't she? She says that they were just two regular moms who were, getting together to commiserate about the fact that they were both being harassed by Aidan Kearney. And that may be one of the ways. And I don't remember if it was during trial 2 or trial 1. I hate 1.0, 2.0, and I will never say that to you ever. It's season 1 and season 2, or trial 1 and trial 2. And so I think it came up during at least trial 1. Did it come up on trial 2, you guys? About Jen McCabe going to Proctor's house? And, they were just two normal moms commiserating over the fact that they were both being harassed. That's the way I remember it. Now, I don't think that was Lank's wife, because Lank's wife wasn't being harassed, right? They went to Lank's. Stephanie, I have not watched it, but I think we should watch it. The Walsh hearings, in which many of these same players testified. Because remember, Walsh, the Brian Walsh case, or the Anna Walsh case, I should say, was exactly almost to the day 1 year after John O'Keefe's murder. That was in around New Year's Day, 2023. Sandra Birchmore was 1 year, almost to the day, before John O'Keefe's murder, something like beginning February 2021, correct? And the year before that, again, almost to the day, was the murder of Katie McLean by Dr. Harry Turk. So it's like every year in the winter during a nor'easter, crazy stuff goes down in Norfolk County. All of these are Norfolk County cases. Sandra Birchmore was also murdered in Canton. So there's that. Okay. Yeah, so we have been also, thank you, Goodmans, for gifting 5 memberships. You're amazing. Amazing. They watch me on date night. Can you imagine? Mr. and Mrs. Goodman try and outdo each other with the gifting and the super chats, and I love them so much. And look, they have my logo as their profile pic. Okay. Back to the document. My eyes are hating me right now. B, as applied, challenge to General Law 268-13A and General Law 268-13B. As noted, General Law 268-13A prohibits individuals from picketing or parading in or near a witness's residence if done with the intent to interfere, obstruct, or impede the administration of justice, or with the intent to influence any witness. And GL 268-13B prohibits directly or indirectly, willfully intimidating or harassing a witness, potential witness, police officer, or investigator in a criminal proceeding of any type with the intent to impede or interfere with a criminal investigation or proceeding, or with reckless disregard for whether such impedance or interference may result. An as applied challenge to these statute requires an analysis of the facts of a particular case to determine whether the application of a statute, even one constitutional on its face, deprived the individual to whom it was applied of a protected right. Kearney is charged under GL 268-13A for his actions related to the rally. He contends that during the rally, he was engaged in lawful assembly, utilizing lawful speech, and did so in a traditional public forum. The court is not persuaded for 2 reasons. First, contrary to Kearney's contention, the Commonwealth is permitted to regulate protected speech and expressive conduct, so long as the regulation passes strict scrutiny. As discussed in Section 1A, General Law 268-13A and General Law 268-13B passes strict scrutiny, or they both pass strict scrutiny. Thus, even if the statute permits him to be charged while engaged in protected speech, it does not make the statute unconstitutional as applied to him. Second, it has never been deemed an abridgment of freedom of speech or press to make a course of conduct illegal merely because the conduct was in part initiated, evidenced, or carried out by means of language either spoken, written, or printed. With respect to the rally, it could be concluded that the purpose of Kearney's speech was to interfere with, obstruct, or impede the administration of justice, or to influence the witnesses in the Reed case, to influence the witnesses. Well, I don't know. Wasn't he just telling them to tell the truth? I don't know. I don't know. Look, whether this is appealed or not remains to be seen. And again, this is just a motion to dismiss on the papers. After testimony at a trial, who knows what could happen. In organizing the rally, Kearney's choice of location were the witnesses' homes, a location that has long been recognized as an individual's safe haven. See Frisbee v. Schultz, 1988. And notice here also, this Judge Doolin is citing U.S. Supreme Court cases. He's not dicking around with only Massachusetts case law, which we've seen a lot in the Karen Reed trial. So the fact that he's really dotting his I's, crossing his T's, and took, at least 90 days to render this decision, it's well reasoned so far, in my opinion. And we'll see if it survives an appeal. But I mean, he certainly put a lot of work into this, or he or his law clerk or law clerks did, in any event. As noted, General Law 268-13A does not prohibit all picketing and parading. It merely prohibits such activity when done in or near a witness's residence with specific criminal intent. Kearney could have chosen different venues. The fact that the rally took place outside of the witnesses' homes and involved dozens of participants is critical in determining whether such rally took place with the intent to interfere with, obstruct, or impede the orderly administration of justice. Citing a Massachusetts case from 2016 and a U.S. Supreme Court case from 78. In considering the First Amendment protective reach, critical to the examination is the context and the content of the speech at issue. We're getting there, Lisa. We're getting there. It's denied in part and granted in part. So we'll see which part was denied and which part was granted. Kearney has also not shown that 268-13B is unconstitutional as applied to him. Kearney is charged under GL 268-13B for his actions related to various broadcasts, blogs, other protests, and unexpectedly showing up to witnesses' homes, businesses, meetings, and sporting events. Although he contends his speech related to these charges did not constitute true threats or fighting words, one could have a different interpretation. Kearney's broadcasts include veiled threats, such as saying the witnesses do not have a right to live peacefully. And then he's citing the specific episodes. That the Alberts should be afraid of him. And that he is informed of the witnesses' locations. Period. Whether Kearney's conduct qualified as true threats or fighting words is left for the trier of fact. And so that's what the judge is saying here. This is going to be up to a jury or the judge, if he chooses a bench trial, to decide. And it's not for him to decide in this particular motion. Moreover, as discussed above, the Commonwealth has a compelling government interest in assuring the administration of justice is fair and orderly. And Section 13B is narrowly tailored to achieve that interest. Kearney's broadcasts, phone calls, voicemails, and unexpected visits to witnesses' homes, businesses, and meetings reflect a pattern of conduct done with the intent to influence and or interfere with the Reed case. Footnote 29, which says, in fact, Kearney, in Exhibit 80-30-23, jury influence, admits that this is exactly what he's trying to do. See also episode 604, I do not want this to go to trial. Understand also, I'm breaking from the document for a second to say that deciding this motion, the judge has to see the facts in the light most favorable to the Commonwealth for purposes of deciding this motion. And so that is why he's leaving certain things to the trier of fact, which would, as I said, be the judge if it was a bench trial, or the jury if it's a jury trial in this case. In many of his broadcasts and protests, Kearney urges the witnesses to tell the truth, which he admits can certainly influence a witness and may obstruct or impede a proceeding. Docket number 68, pages 16 and 17, footnote 30. A lot of footnotes in this decision. 30, Kearney also urges witnesses to tell the truth during the rally. It would be reasonable for a fact finder to conclude that he is simply urging the witnesses to tell his version of the truth, and such speech can be found to influence a witness. And here's a case that seems to be on point. U.S. v. Cruzado Laureano, which is a First Circuit case from 2005. Defendant's conviction of witness tampering stands because the jury could have found that the defendant was trying to persuade a witness to testify to something other than the witness's true beliefs. Accordingly, Kearney has not demonstrated that to the court that as applied to him, the application of the statutes is unconstitutional. Footnote 31. If Kearney has not provided this court with any cases that would support his as-applied challenges, specifically, he has not provided any cases that support the notion that the Commonwealth cannot restrict protected speech or expressive conduct in order to further a compelling government interest. Roman 2, challenges to the grand jury proceedings. Ordinarily, a court will not inquire into the competency or sufficiency of the evidence before the grand jury. However, a court may consider whether the evidence presented to the grand jury was sufficient to support the existence of probable cause to arrest, or whether the integrity of the grand jury proceeding was impaired. Here, Kearney argues that the evidence was insufficient to establish probable cause that the crimes for which he was indicted had been committed and that he had committed them, and that the integrity of the grand jury proceedings was impaired. A, probable cause to indict. To sustain an indictment, the Commonwealth need only present sufficient evidence to warrant a finding of probable cause to arrest the defendant for the charged offenses. Probable cause is a considerably less exacting standard than that required to support a conviction at trial. It requires sufficient facts to warrant a person of reasonable caution in believing that an offense has been committed, not proof beyond a reasonable doubt. For the indictments to stand, the grand jury must be presented with evidence on each of the elements of the offense charged. The court views the evidence presented to the grand jury in the light most favorable to the Commonwealth. Oh, I just said that. Small numeral I, General Laws 268-13A. Kearney was indicted on 5 counts of unlawful picketing to influence a witness in violation of General Law 268-13A. As noted, this statute makes it unlawful for individuals to picket or parade in or near a witness's residence if, in doing so, they intend to interfere with, obstruct, or impede the administration of justice or influence said witnesses. These indictments pertain to Kearney's involvement with the rally that took place on or about July 22nd, 2023. Footnote 32. It is uncontested that Kearney on July 22nd, 2023 did picket or parade near the residences of witnesses Brian Albert, Jennifer McCabe, Matthew McCabe, Michael Proctor, and Juliana Nagel. Kearney argues that because he did not use criminal speech while picketing the various witnesses' homes, the indictments against him cannot stand. For Kearney to be indicted under General Law 268-13A, the Commonwealth was required to establish probable cause that Kearney's conduct in regards to the rally was done with the intent to interfere with, obstruct, or impede the administration of justice or with the intent to influence a witness. Because matters of intent are rarely proved by direct evidence and are most often proved circumstantially, Kearney's intent can be inferred from the place, time, and circumstances of the rally. Kearney organized and led a caravan of vehicles to the residences of witnesses Brian Albert, Jennifer McCabe, Matthew McCabe, Trooper Proctor, and Juliana Nagel. Each witness testified that a large group of people, ranging from approximately 25 to 75 individuals, arrived outside their homes. In addition to the large group of people, Kearney used a bullhorn to inform the witnesses' neighbors that the witnesses were murderers or part of an alleged cover-up. The facts and evidence submitted to the grand jury gave rise to a reasonable inference that Kearney's conduct, coupled with his speech, were done with the intent to obstruct, interfere with, or impede the administration of justice, or with the intent to influence the witnesses. Because Brian Albert, Jennifer McCabe, Matthew McCabe, and Juliana Nagel were home during the rally, and therefore subject to Kearney's conduct and speech, the court concludes that the grand jury heard sufficient evidence to indict Kearney under 268-13A as pertaining to them. However, because Trooper Proctor was not home during the Rolling Road rally, the court concludes that the grand jury did not hear sufficient evidence to indict Kearney as pertaining to him. Okay, there's one that's dismissed. Proctor, Rolling Rally. He wasn't home. Therefore, He shouldn't have been indicted on that charge. That's a win. General law, Little Roman 2, General Laws 268, 13b. Kearney was indicted with 8 counts of witness intimidation in violation of General Law 268, 13b. As noted in pertinent part, that statute provides that whoever willfully, either directly or indirectly threatens, attempts, or causes physical, emotional, or economic injury or property damage. See, here's the difference in the Massachusetts statute. If you cause someone emotional harm, if you hurt their feelings, you can be prosecuted under the statute. I think it's overly broad. It's my personal opinion, but I don't think the judge thinks so. Or misleads, threatens, intimidates, or harasses another person who is a witness or potential witness or police officer or investigator or family member of a person described in this section at any stage of a criminal investigation. So it could be even a family member of a witness or the wife of a police officer. Grand jury proceeding, trial, or other criminal proceeding of any type with the intent to impede, obstruct, delay, harm, punish, or otherwise interfere thereby, or do so with reckless disregard with such a proceeding shall be punished. The statute defines harass as an act directed at a specific person or group of persons that seriously alarms or annoys such person or group of persons and would cause a reasonable person or group of persons to suffer substantial emotional distress. Under the statute, to intimidate means acts or words that would instill fear in a reasonable person. Again, these are all questions of fact that need to be decided by a jury, and that's my opinion that's why the judge is not deciding them himself. To communicate indirectly requires evidence that defendant intended such threat to be communicated to the targeted individual. Said another way, for the Commonwealth to sustain an indictment under General Law 13b, it had to present evidence that Kearney had willfully, directly, or indirectly threatened, attempted, or caused physical, emotional, or economic injury, or threatened, intimidated, or harassed a witness, potential witness, or family member of a witness, or potential witness in a criminal proceeding of any type with the intent to impede, obstruct, or interfered with a criminal proceeding, or in reckless disregard of the impact his conduct would have in impeding or interfering with that investigation or proceeding. As to the intimidation of Chris Albert, Kearney contends that the Commonwealth's evidence was insufficient because it did not present any evidence that Kearney's speech constituted a true threat or fighting words. In support, Kearney repeatedly asserts that because a different judge declined to issue a harassment prevention order on First Amendment grounds, the indictment cannot stand. Assuming without deciding Kearney's speech does not constitute a true threat or fighting words, speech that is otherwise lawful can fall outside the scope of constitutional protection depending on the context and purpose of the speech. The grand jury heard testimony from Chris Albert and watched numerous video exhibits which supported the requisite elements. Kearney's actions were directed at Chris, and the grand jury could have reasonably found that Kearney's actions and words were harassing or intimidating. Specifically, in various video exhibits, Kearney advises Chris and his family to stop going out in public and shares that he is aware and informed of Chris's whereabouts. See these 2 or 3 episodes and footnote 33, which says, in this video, Kearney states the following: if you go out in public and you go to the grocery store or wherever, people are taking pictures of you. I've got a picture of you, Chris, and your wife, Julie, because I know you're watching, Chris. It's about a week or so ago. You went to the Twin Rivers Casino, didn't you? I got pictures of you at Twin River Casino. Like turtle riders, we're going to find you. They're going to find you. Any turtle rider sees you in public, they're going to do this. They're going to take pictures of you. They're going to send it to me. We need to accelerate it. I'm not telling you what to do, but inaudible. Fantastic job with this. Fantastic job. On numerous occasions, Kearney stood outside of Chris's restaurant while yelling Chris and his son Colin were murderers and accosted customers as they left, asking them why they would support a murderer such as Chris. Based on the foregoing evidence, the grand jury could have reasonably found that Kearney's solicitation of his followers to order food from Chris's restaurant and not pick it up and pay for it, were designed to and did inflict economic or emotional injury. Furthermore, the grand jury could reasonably interpret Kearney calling Chris a murderer, unexpectedly showing up at his restaurant and telling Chris that he would leave him alone if he and Colin came clean about O'Keefe's death as harassing or intimidating behavior intended to or with reckless disregard for the fact that it may interfere with Chris's role as a witness in the Reed case. As to the intimidation of Colin Albert, the Commonwealth established probable cause that Kearney had intimidated Colin in violation of the statute. Specifically, Kearney broadcasted Colin's cell phone number and then left a voicemail with which the grand jurors could have found aggressive, harassing, or threatening. The grand jury could have reasonably found that Kearney's statements that he would show up at Colin's practices and games until he quit the football team as threatening, intimidating, or harassing, especially in light of the fact that Colin chose to not play football in 2023 in order to prevent such conduct. Moreover, the grand jury could have reasonably attributed that the purpose of Kearney's conduct was to interfere with Colin's testimony in the Reed case because Kearney said he would leave Chris and Colin alone if they came clean about O'Keefe's death. As to Jennifer McCabe and Matthew McCabe, the grand jury heard sufficient evidence to warrant a finding of probable cause of witness intimidation as to both of them. Kearney has unexpectedly shown up to the McCabe's residence and filmed the inside of their house. Such conduct very well could have been done to intimidate or harass Jennifer and Matt. Period. Moreover, Kearney unexpectedly making an appearance at Jennifer and Matt McCabe's two oldest daughters' lacrosse game, filming them, as he calls them, cop killers, and then subsequently stating that he made a scene and got kicked out of the lacrosse game because he kept calling Jennifer a cop killer, is evidence that Kearney intended to harass and impede, obstruct, delay, or interfere with Jennifer and Matt's roles as witnesses in the Reed case. Footnote 34. This is also supported by the fact that Kearney has stated he is happy Jennifer McCabe has been shamed into not attending court. In sum, Kearney's conduct, particularly in the context of showing up to the McCabe's daughter's high school lacrosse game, is evidence of intentional conduct that is harassing, intimidating, or threatening with intent to punish the McCabe's and impede a criminal proceeding. Therefore, the grand jury heard sufficient evidence as to indict Kearney under GL 268-13B. As to Elizabeth Proctor, the grand jury heard testimony that Kearney disseminated her employment information and encouraged his followers to post negative comments about Elizabeth on her employer's social media pages, which they did. Additionally, Kearney's public sharing of Elizabeth's personal phone number, along with the content of the voicemail message, could reasonably find Kearney's conduct to be harassing, intimidating, or threatening with the intent to impede, obstruct, or otherwise delay the Reed case, which her husband was heavily involved in. And here's a Massachusetts case which says posting victims' personal information online done to ensure that the victims were harassed by telephone and showing up at their home. Therefore, the grand jury heard evidence sufficient to indict under General Law 268-13B. I have questions though. Didn't Elizabeth Proctor, and you can tell me if I'm wrong, do the same thing to a lot of people who didn't think John O'Keefe was hit by a car and call their employers and post things online and stuff like that? She has not been charged under the statute. Have any of the people who broadcast Dr. Crash Daddy Wolf's personal information and photos of his family and all of his Facebook in an attempt to prohibit him from testifying, in an attempt to strong arm him into not testifying in the Karen Reed trial? And have any of those people been charged under this same exact statute? It's like you can't use it as a shield and a sword. You can't go after Turtleboy for doing the same things that other people are also doing and not prosecute those people. I mean, it has to be equal. The application of this law has to be equal. And it's not, because they did the same thing to Richard Green. You're right. And they are witnesses. They're expert witnesses in the Karen Reed trial. And that was intentionally done to try and get them to back off from testifying at her trial, in my opinion. Or it could be construed that way, right? But have any of those people been charged? No, they haven't. As to Juliana Nagel, the grand jury heard testimony that Kearney has posted articles accusing Juliana that she's part of the cover-up of O'Keefe's death and that she needs to tell the truth. Juliana testified that she believes Kearney has posted articles making such accusations because he wants her to change her testimony. While Kearney asserts that the grand jury heard no direct evidence that he intended to impede or interfere with the Reed case or did so in reckless disregard of the impact it would have, the grand jury was permitted to draw reasonable inferences pertaining to Kearney's intent from the circumstantial evidence presented. And as noted above, telling a witness to tell the truth, as in their version of the truth, can be done with the intent to influence a witness's testimony. Therefore, a grand jury heard evidence insufficient to indict. Okay, remember also, we went over pre the first Karen Reed trial, they made a very similar motion. It was the motion to dismiss the indictment against Karen Reed because of all of the shenanigans that went on in front of the grand jury. And it had to do with the Aruba witnesses being allowed to testify improperly. It had to do with Proctor not telling about his close ties with the Alberts to the grand jury. And a lot of things were misrepresented to the grand jury. And there was a lot of evidence that those indictments should have been dismissed, in my opinion, and they weren't. So this is similar to that motion. I don't think anybody ever thought that this was going to be granted in its entirety, but I'm going to say that we're going to keep reading. And with regard to some of the indictments that were dismissed, that's a win. That's a win because that rarely happens. So reading on, as to Michael Proctor and Yuri Buchanan, however, the court is persuaded that the evidence presented was insufficient to sustain the indictment. Well, there you go. With respect to Proctor, the grand jury watched a video of Kearney call Proctor's work phone, repeat his work phone number, and leave an ominous voicemail. As a result of the broadcast, Proctor received a number of messages and calls, causing him to change his phone number. With respect to Buchanan, the grand jury were informed that on or about September 15th, 2023, as Yuri Buchanan entered the Norfolk Superior Courthouse, Kearney hurled insults and epithets at Yuri Buchanan. While Kearney's conduct of sharing Proctor's phone number and the context of his voicemail message are distasteful and his statements to Buchanan are insulting, it is not clear that his conduct in either regard was intended to impede, obstruct, delay, or prevent or interfere with the Reed case. As such, the court finds that the grand jury did not hear evidence sufficient for those two indictments under 268.13b. Okay, so that's 3. So the first one, Proctor wasn't home during the rolling rally, dismissed. And then another one against Proctor and Buchanan, dismissed. And that's dismissing the indictment outright. I mean, that's a pretty big win. So that's 3. Little Roman numeral 3. General Laws 274, Section 7. The grand jury indicted Kearney on 3 counts of conspiracy in violation of General Law 274.7. For the Commonwealth to sustain an indictment under this statute, it must show that Kearney entered into an agreement or plan with at least one other individual, that the purpose of the agreement was to do something unlawful or to do something lawful by unlawful means, and Kearney joined the agreement knowing of the unlawful agreement with the intent to help carry it out. Okay, so these are the ones with regard to Janelle Webb. So the 3 indictments with regard to Janelle Webb. Here, the grand jury heard testimony that Webb ran 3 license plate numbers in September 2023 at the request of Kearney. Despite this, however, the grand jury did not hear sufficient evidence to indict Kearney on a conspiracy. Specifically, the Commonwealth did not present sufficient evidence to support the notion that Kearney requested Webb run the license plates for the purpose of intimidating or harassing Jennifer McCabe, Michael Proctor, or Elizabeth Proctor. Therefore, the grand jury did not hear sufficient evidence to indict Kearney of conspiracy to intimidate under General Law 274, Section 7. That is 3 more indictments dismissed. If you're keeping track, the first one is Proctor. First one, then 2 and 3 are the Proctor and Buchanan. And then 4, 5, and 6, Jen McCabe, Elizabeth Proctor, Michael Proctor. B, impairment of the grand jury proceedings. Kearney argues that the integrity of the grand jury proceedings was impaired and the indictments against him should be dismissed because the prosecutor, 1, failed to provide curative instructions explaining that actions by third parties cannot be attributed to Kearney, 2, misstated the law, and 3, elicited improper opinion testimony. The court disagrees. And this was Mello, right? This was Mello, who was the who conducted the grand jury. And remember, a grand jury is something that's done in secret. It's one-sided. It is only the prosecution. The defendant doesn't even know what's happening and it never testifies, is not represented by counsel, and so is one-sided. And that is the nature of grand juries. And as Saul Walkler, the infamous Chief Justice of the highest court in New York, once famously said, a good prosecutor can get a grand jury to indict a ham sandwich. Well, according to Judge Doolin, 6 of these indictments should be thrown out. It is well settled that prosecutors are not required in every instance to reveal all exculpatory evidence to a grand jury. Rather, the integrity of the grand jury proceedings has been impaired and dismissal is warranted when the omitted exculpatory evidence would likely have affected the grand jury's decision to indict. Similarly, the presentation of false or misleading evidence only requires the dismissal of an indictment where the evidence was presented with the knowledge that it was false, with the express purpose of obtaining an indictment, and probably influenced the grand jury's determination to hand up an indictment. The defendant bears a heavy burden to show the impairment of the grand jury proceeding. 1. Curative instruction. Kearney argues that 3 witnesses' testimonies regarding the actions of other individuals may have resulted in Mr. Kearney being indicted for the alleged actions of others. Specifically, Kearney takes issue with Jennifer McCabe's testimony that people drive by and scream at her family. They stop and they yell and they take pictures of her house and of her kids and of herself and they post it or send the pictures to Kearney. It's almost like they get rewarded. Kearney also argues that Elizabeth Proctor's testimony that Kearney's followers email her and leave her voicemail messages targeting her children, and Michael Proctor's testimony that on the day of the Rolling Road rally, protesters parked on his lawn and spat at his house was highly prejudicial as it impermissibly attributed actions of third parties to Kearney. Contrary to Kearney's assertions, the prosecutor was not required to provide curative instructions. Insofar as Kearney is arguing that the witness's testimony was false or deceptive, and that such testimony probably influenced the grand jury's decision to indict him, his arguments fail. As discussed above, there was sufficient probable cause for the grand jury to infer that Kearney posted videos in organized gatherings with the intent to incite third parties to harass the various named witnesses. Moreover, even if the actions of the third parties could not have been attributed to him, there was sufficient evidence of Kearney's own conduct to support the grand jury's decision to indict him. Therefore, Kearney did not meet his burden of showing that the evidence he claims should not have been heard by the grand jury probably made a difference in the grand jury's decision to indict him. Roman II, misstating the law. Kearney also asserts that the prosecutor impaired the integrity of the grand jury proceedings when he failed to instruct the grand jury on the limits related to any alleged harassment that served as the basis for the allegations. Specifically, Kearney contends that the prosecutor failed to address First Amendment protections, which protect speech constituting political hyperbole. This argument misses the mark. The grand jury are an investigatory body with a dual function, determining whether there is probable cause to believe that a crime has been committed and protecting citizens against unfounded criminal prosecutions. Because of the availability of an unprejudiced petty jury at trial, the safeguards deemed necessary to protect an accused before a petty jury are not complicit to the same degree in grand jury proceedings. As such, the Commonwealth is not required to present evidence of so-called defenses or otherwise disprove such matters before the grand jury. 3, improper opinion testimony. Finally, Kearney argues that the prosecutor impaired the integrity of the grand jury proceedings by eliciting improper opinion testimony. Specifically, Kearney asserts that rather than presenting evidence of Kearney's intent to intimidate Juliana Nagel, the prosecutor asked Juliana, "In your opinion, is Kearney trying to get you to change your testimony?" To which Juliana answered in the affirmative. Although this testimony may have been improper, it likely did not affect the grand jury's decision to indict. Testimony that is improper must, when viewed in the context of all the evidence presented to the grand jury, makes a difference in the jury's decision to indict the defendant in order to be considered an impairment of the integrity of the grand jury proceedings. As discussed above, the cumulative evidence presented against Kearney was sufficient for the grand jury to infer Kearney's intent. Footnote 36, which says, Kearney also raises this argument as to Elizabeth Proctor. Specifically, he asserts that the prosecutor impermissibly asked Detective Lieutenant Tully Any other incidents that you feel were intimidating to Elizabeth Proctor? This argument fails for the same reason. Conclusion or order. For the foregoing reasons, Kearney's motion to dismiss is allowed as to indictments number 4, 8, 12, 14, 15, 16, and otherwise denied. XOXO. Michael P. Doolin, Justice of the Supreme Court, dated May 19th of 2025. 37 pages long, but in all of those 37 pages, 6 of the indictments were dismissed, and that's a big win. I mean, that rarely happens on a motion to dismiss the indictments, that 6 of them are dismissed. It just rarely happens. And so there's that. The turtle you know says I had problems with my boss. Oh, because Elizabeth Proctor called and said something about you? Hmm. Lindsay, Melanie, if the rolling rally was illegal, why did Canton PD chaperone the entire thing and not say a word about it? Well, I don't think the rolling rally in and of itself was illegal. I think the allegations are that some of the things that he said while going to their house could have led them to feel intimidated or harassed under the statute. And so therefore we have to wait until a trial to see what a jury decides. That is the crux of this ruling. Josh, all of these people testified, so they factually weren't intimidated into not testifying. True. All Turtleboy said is for them to tell the truth. True. But again, that's not for the judge to decide in this motion. That's for the finder of fact to decide, which will be either a bench trial or a jury. But 6 of the indictments were dismissed, and that rarely happens. So you got to look at the bright side, or he does anyway. Aidan does, because 6 of those indictments were dismissed, which just Mimi Sue, I saw on replay you got to 100K. Congratulations. Oh, thank you. Thank you so much. Thank you for your confidence. I appreciate you, Mimi Sue. Lindsay, his conduct was so criminal, it took a special prosecutor and 7 months to charge him, even though there were cops in attendance that day who witnessed said conduct. Yes. 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 I wanted to go to the to see if there's a trial. Is there a trial date scheduled? And does anybody in the chat know when the trial date for this is? Because I'm sure it's going to be, is it going to be after Karen Reed's case is done, do you think? Let me just pull it up here. Right. Where's the evidence Turtleboy ever told people to order food and then not pick it up? There's no evidence of that. Right. Again, those are issues for the finder of fact, which is the jury. This was merely a motion to dismiss the indictments, saying that he was improperly indicted. Yeah, I thought it was June 9th too, or June 9th or June 6th. Let me just see what I can see here with regard to events. 6 out of how many? So 6 out of 16, right? I think there were 16 total. 6 were dismissed, so there's 10 remaining, and that's going to be for a finder of fact. And I think you're right. I think it's June 9th. So hang on. I don't know if everything is all under the same index number, because this one has conference to review status, but this looks like it's the Lindsay case, but this is under, and that's in front of Judge Halal on June 20th. That's at 2 p.m. And then the other one must be under a different index number or docket number. Yeah, you said I think it's during Karen's trial. June 9th is the trial for violations of the HPO of Lindsay. So what is the? It's under a different number. If anybody knows, you can know. Oh, good. I'll tell you about the march. Let's play the video of Marcy. Hang on a second. Uno momento. And this is Aidan posted this morning. I don't know where he got the video, if it's his video or someone else's video. And here's what the post says. A woman at the Quincy Memorial Day Parade yelled, "Remember to free Karen Reed" at Michael Morrissey as he walked by, getting exercise for the first time in at least a year, Aidan says. Morrissey yelled back, "She is free, by the way." Morrissey has refused to hold a press conference with anyone in the media since indicting Karen Reed. And here's the video of it. So hang on. Turn this on and then rewind it. Here's Morrissey right in the middle. He's the shortest one in the middle section.
Be nice to free Karen Reed.
Did you already said she is free, by the way? The woman says, "Be nice to free Karen Reed," and he looks right at her. She is free, by the way. I'm gonna enlarge it as much as I can for you. Hear it again.
She's not free. You know that. Karen Reed.
Hold on. Take it back a little bit.
Be nice to free Karen Reed. She's not free. You know that.
And that, my friends who live in Norfolk County, that is your district attorney. Congratulations. Make sure you vote in the next election, okay? Make sure you vote. He's coming up for re-election in 2026, right? Yeah, he said that. Are any of the reporters covering this? Like all the mainstream media reporters gonna cover that? Sandra, thanks for the Venmo, says Anna Walsh was the next year, January 4th, 2023, too. That right? Yeah, I guess our messages crossed. Great mind, Sandra. Thank you. Thank you very much. So that's your district attorney, Michael Morrissey. That's what he thinks. Like a communist dictator, says Thomas. I don't know if that was Dina. I don't know who it was. It didn't say. It just said a woman. Melissa said that lady just ruined his whole day. AJK, just last week, Marcy had his MSP henchman arrest a woman wearing a Microdots hoodie, which simply said criminals control Norfolk County. Yeah. And she had to take it off. And underneath that, she had a Turtleboy shirt on. Her name's Erica. And then she had to walk to her car. She had to take that shirt off too and walk to her car in her sports bra, because that's what's going on in Norfolk County, where the Constitution and goes to die, apparently. And so we'll be back here tomorrow morning at 9 a.m. to cover the continuing saga of the re-persecution of Karen Reed. Final thoughts, comments, questions, concerns, my friends? That's interesting. Babs Board Games said, didn't he just break the gag order by responding? That's interesting. Not supposed to be talking about the case, right? Kim Robinson says the same thing. Marcy just violated the gag order. Miranda says, what kind of district attorney yells back? Erica was arrested. Yeah, she was arrested. I mean, I came across this, like, I was really busy last week, admittedly, so I don't know what happened to Tom CPU, but wasn't Tom CPU also like grabbed and perhaps assaulted by one of these MSP troopers? Right? Or did I overstate that? Wendy wants to know if the FBI is still on this. I don't know. They definitely don't announce when they've closed investigations, so I think perhaps they are. Many people seem to think so. I don't even want to address all of the other stuff that I was sent on Twitter that is just gross. People out there spewing disgusting things about Karen. Just gross. Just the whole thing. This whole thing is gross. Oh, here's something from Microdots. Hang on. That was posted, I think, yesterday. It's a good one. Let's look at this. Because so many of you that are new to this case don't know all of this stuff that went on pre-trial Karen Reed. Microdots has all of the amazing information and things and stuff. Microdots says, no one ever talks about way back in 2022 when Trooper Proctor played hide the football with the geofence data. Although the motion was granted by Bev's predecessor, Judge O'Malley, Proctor made sure they never received it, and Lally helped. And this is a clip from Geodeception. Go follow Microdots on everything, all the social media. And this one is 6 minutes long. Can I play it? Is there music in it? I don't know. Will Richie be cool? I think Richie will be cool with it, but I don't know if there's, do you guys want to see it? Or do you want to go look for it yourselves? Let's look at the first part of it.
Began earlier this afternoon, and her defense says prosecutors are withholding information.
We had a lot of difficulty getting cooperation from the prosecution and turning over the information that they have.
I don't know. The music might strike me, so I don't want to get stricken. So you guys go look for this yourselves, because I'm sure Microdots bought the rights to the music, and so he can play it, but I can't. If I play it, it might strike me. So go to Microdots. This is called what is this called? It's the new, I guess it's the newest dropping of Microdots. This was posted the 24th. What's today? Today's the 26th. Geodeception. This might be an old one. Is it old or new? It's a classic. Thank you. Hi, Olivia. Hi, Olivia. Yeah, Richie is incredible. Richie is incredible. Go check it out. If you choose to wait on the cesspool of Twitter, you can find it there. I'm sure it's also on Microdots. Yeah, the geofencing. Remember the geofencing? The geofencing. Proctor only requested geofencing data for Android phones for all of the people that were at 34 Fairview, and everyone inside the house had an iPhone, right? So this is called Geodeception. Go watch it. It's on his YouTube. Excellent. It is on his YouTube. Thank you. Oh, snap, Sharon. Melanie Little's left swipe in StreamYard says the case is still open with the DOJ. All right, my friends, it has been so much fun spending part of my Sunday together. Today's Monday. Okay, it's Monday. I don't know what day it is. It's Memorial Day. So much fun spending my Monday with you. Part of it anyway. Tomorrow we will be spending the whole entire day together. So don't forget, tomorrow we're going to be here 9 a.m. doing it all over again. And I have the feeling Judson Welcher is going to take the stand, and I can't wait to see what Olivia's dug up on him this time. Olivia, have you dug up anything? Don't post it on Twitter. Don't give him a heads up if it happens. If you did. Yeah, it's going to be Judson Welcher tomorrow. And can Judson Welcher save the Commonwealth? A brain surgeon couldn't save the Commonwealth, but can a Judson Welcher, who's from Aperture, which is the same disgraced company that inflated Shannon Burgess's credentials? Because listen, if they didn't vet him thoroughly, it's their fault. And if they did vet him thoroughly and they didn't find out that he was lying, then that's also their fault. And if they published false documents and CVs of Shannon with one N, that's also their fault. And so, RIP Aperture, I guess, at this point. Right. Don't give him the heads up, JB. Don't do it. Don't do it. Thanks, mods, for keeping the chat classy tonight. It probably was hard in there. I know it's hard when we cover this case. It's hard when we cover Karen Reed. It's hard. But you know what? That doesn't stop us because we're not afraid of the hard stuff. Somebody's got to talk about it, right? Welcher, I believe, is going to be the last Commonwealth witness. That is mind-blowing to me because they didn't call Renee Stonebridge, the doctor who examined John O'Keefe's brain, who I think is a great witness for the defense. So I'm hoping that they call her. They did not call James Crosby, the guy who went and did all the molding of Corey/Chloe's teeth, the only dog to ever enter witness protection. I guess they're calling him on rebuttal. They didn't call the dog DNA expert, Terry Kuhn from UC Davis. So there's a lot of stuff. That they haven't called. And this guy has got to be like the ringer. He's got to be the one who could tie everything together. Because so far, I haven't seen any evidence that John O'Keefe was hit by a car. A couple of pieces of mysterious taillight that wound up on the lawn in the area somewhere near where maybe John O'Keefe's body was found. It's not convincing me. A stray hair that could have been from anyone in the maternal line of John O'Keefe's family is not convincing me. And some touch DNA on the outside of the taillight is not convincing me either. So I don't know. Maybe other people are more easily influenced, but I'm not. Miss Jessica NB says, I was feeling really down this Memorial Day, thinking of all my lost fellow vets. Thank you for hosting. Thank you for your service. Thank you to all of my other service members and retired service members, active, retired, in the chat and in our group, and to all of you that have lost family and friends and fellow vets, my heart goes out to you. We thank you all for your service and for standing up for our country, those who gave their lives in defense of our country. We thank you. I don't even know if there are words to really thank any of you enough. And so today is the day to honor you, and I'm happy that I was able to distract you for at least a little bit by going over this 37-page decision that I'm not sure if anybody else has read. So although it's a week late, it's still important. Sue Mo, I have sent you many cash chats and other messages, and I get nothing. What do you mean? I don't know what you mean, Sue Mo. I always put them up on the screen. If it's during a 20,000 person stream today, it was about 6,000, so it's been lighter. I have not seen anything from you, and so I'm not sure what it is that you're exactly looking for. But I'm not seeing. I mean, you're not Sandra. I talked about Sandra already. I'm not seeing anything from you in Cash App or Venmo, so I'm not sure exactly what it is I'm doing to upset you, or that I owe you or haven't read. So I'm not really quite sure, Sue, but all of those ones. Thank you. Let's do the timeline again. They've arrested Erica since then. A second indictment. Oh, really? A second one. So the first one wasn't good enough. Now there's two. Brian, DA marching in an empty street speaks volumes. Yep, that was the Memorial Day parade today. So there's that. Sue, if you want to put your question in the chat, I'm happy to answer it. I'll wait a second for you to put it in there. But there's a lot of trolls in here who just do that kind of thing for attention, not saying that it's you. No replies? What do you mean no replies? I don't know. Are you saying that you've sent me emails and I'm not replying to you? I always answer. Every single chat is always personally thanked and is always put up on the screen. And trust me, when there's 20,000 people in the chat on a regular trial day, there could be hundreds, and they always get up there. And so there's that. Haas Dare You is on Microdots. That's cool. I haven't seen anything from Sumo either, so not really sure what she's referring to, but we have ways of seeing, and the moderators have ways of seeing every comment that a viewer has ever left. So not sure. On the last chat, on the last show or another show, which was the last time you ever commented in the last year besides today, was on a show that was before the trial even started. And you wanted to know if all Americans smoke weed because it's illegal and gross. And so I'm not sure. And the last time you put a super chat in was in March 4th of 2025. And you said, OMG, Brennan lied again. He said in court, it's over, looking into O'Keefe's death and all related matters. The statement did not say that. And so I can see everything. I can see everything. And so, Sumo, if there was something else that you sent me that I haven't, you're still here. I can see you. You're still here. I see another super chat, but that was back. Betero was new Commonwealth motions. Like that was way, way, way pre-trial, way pre. So please don't feel offended. I can't, try and thank everybody. And I also try and respond to lots of questions that people do not super chat about. So if you know, like Kelly. So did you see Turtleboy post about the parade with Mars? What he said about Karen? Yes. Thank you for putting that out, Kelly. For all of you for being here with me today. I love you with all of my heart. And if I don't see you soon, I'm going to die. But I'm going to see you tomorrow at 9 a.m. So when I hit end on this, it's going to teleport you right over to the morning stream so that you can hit that bell and you can come right back in the morning. Okay. So I'm going to see you real soon tomorrow. So buckle your seatbelts. Buckle your seatbelts. It's going to be a bumpy ride maybe, but you're going to get over there. You're going to hit the bell and you're going to come back tomorrow. The chat is off for now because I like to give the moderators a break until the morning. I turn the chat on in the morning so that everybody can rest up tonight because we got a full day tomorrow. Full day. And I think we have full days of court every week, every day this week, except for maybe Thursday. Maybe Thursday's a half day. I don't know. Who the hell knows? When is this going to be over? When are we going to hear the magic words? The magic words, not guilty. Hopefully soon. Stay cool, stay kind, stay classy, my friends. Let's have Paris Ray and the Crush play us out. Well, you know what? We can't do that today because I want to teleport you over to the morning stream. We'll do it tomorrow. Everyone go follow Paris Ray and the Crush. Thank you, Sarah. Sarah Saka for getting in here with the last minute super sticker. See, I see you. I see you all. Each and every one. Go follow Paris Ray and the Crush because, you know, it's a nice thing to do. DUI guy is representing Tom's CPU. That's cool. I thought I heard him talking to Will and Annie Elise that he if Tom reached out to him, he would represent him, but I didn't follow up. Yes, we're going to see. We're going to have a big week starting tomorrow. So everyone go get all of the beauty sleep, stay hydrated, and I'll see you in the morning. Buckle up safely. And tomorrow, I think we're going to see Judson Melcher. Okay? All right, everyone. Peace out. Stay cool. Stay kind. Stay classy. I love you all. Hit the like button on your way out and the like button on your way in for tomorrow. Okay? Good night, my friend.